Good morning. We're on the record in case number 2022-00424, electronic tariff filing of Kentucky Power Company for approval of a special contract under its Economic Development Rider and Demand Response Service tariffs with Cyber Innovation Group LLC. My name is Kent Chandler. I'm chairman of the commission and will be presiding over the hearing today. Joining me is Vice Chair Angie Hatton and Commissioner Mary Pat Regan. I'd ask for everyone in the hearing room to please turn off your cell phones or to put them into silent mode. The purpose of our hearing today is to take evidence in this matter. Before we do anything else, we'll take an entry of appearance of counsel for the applicant, Kentucky Power Company.
Good morning, Katie Glass of Stites and Harbison for Kentucky Power Company.
And for the Office of the Attorney General.
Good morning, John Horn for the Kentucky Office of Attorney General.
Thank you, Mr. Horn. Just you today, Mr. Horn?
Yes, sir.
Okay. All right. And for the Kentucky Industrial Utility customers?
Good morning, Kurt Bain with KIUC.
And for joint interveners, Mountain Association, Kentuckians for the Commonwealth, Appalachian Citizens Law Center, Sierra Club, and the Kentucky Resources Council.
Morning, Commissioner Byron Gary, Kentucky Resources Council, on behalf of the joint interveners. Along with me today is Tom Smar.
Okay. Thank you, Mr. Gary. All right. Ms. Glass, I've been advised that the notice was issued within the 7 to 21 day window before the hearing. Is that correct?
Correct, we did not have any issues publishing the notice.
Okay. And you filed evidence of that last week. Is that right?
Yes.
Okay. All right. Do we have any pending motions or issues that we need to take up before we start the hearing today? All right. Pursuant to or consistent with, for commission staff.
Ben Bellamy for Commission.
Thanks, Mr. Bellamy. Pursuant to and consistent with the commission's order and Kentucky Power's notice, the notice that was given indicated that anyone interested in providing virtual public comments this morning could do so by following the instructions on the commission's website, psc.ky.gov. As of a few minutes ago, no one had indicated their interest in providing those comments virtually. Is there anyone in the hearing room this morning not associated with either the applicant or the interveners or the counterparty to the contract that would like to provide public comments? Okay. Seeing no one, I just remind anyone that's watching this in real time or prior to the submission of the case that public comments can be provided prior to the commission taking the case under consideration. There are three ways that you can provide public comments, written public comments. The first is by emailing them to the Public Service Commission at psc.comment@ky.gov. You can also enter them through our website at psc.ky.gov. And you can also mail them to the Public Service Commission, and you mail those to 211 Sower, S-O-W-E-R, Boulevard, Frankfort, Kentucky 40602. We ask that regardless of how you provide your written comments, that you please indicate in your written comments your name, your address, and the case number, which in this matter is 2022-00424. Okay. Given that no one would like to provide oral public comments, I guess we will move on to the presentation of witnesses. Ms. Glass, would you like to call your first witness?
Yes, Kentucky Power calls Brian West.
Mr. West, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Okay, please have a seat and state your name and address for the record.
My name is Brian West. I am the Vice President of Regulatory and Finance for Kentucky Power. My address is 1645 Winchester Avenue, Ashland, Kentucky.
Okay. Thank you, Mr. West. And just to remind you today, similar to last week, you may want to pull the microphone a little closer to you and make sure that you speak up in your responses. I know you get used to it and you get comfortable, but it's hard for us to hear anyone outside the box, even the people that are a little more loud. Ms. Glass, would you like to ask questions of your witness?
Thank you, yes. Mr. West, did you cause to be filed into the record of this case rebuttal testimony and responses to data requests?
I did.
If I asked you those same questions, strike that. Do you have any corrections to either your rebuttal testimony or those responses to data requests?
No, I do not.
If I asked you those same questions today, would your answers be the same?
Yes.
Thank you. The witness is available for cross-examination.
Before, I made a felt silly last week. Have you all come to an agreement about how you would like, an order and what you would like to conduct cross-examination this morning? No, that's okay. Last week, apparently, I was not privy to the conversation. All right, so we'll start this morning with Mr. West, Mr. Boehm, and then Mr. Gary or Mr. Swan. Mr. Warren?
Morning, Mr. West.
Morning.
Do you have your rebuttal testimony handy?
I do.
Could you turn to top of page 4 of your rebuttal testimony? And do you see the question there that says, can you please describe generally the terms of the proposed contract with Cyber Innovation?
Yes.
Okay. Could you mind, on your answer, do you mind reading the last sentence there of your answer?
Further, Cyber Innovation agreed to be interrupted without receiving DRS credits for the first year of the contract.
Thank you. Can you, Mr. West, can you explain what will happen after the first year?
Well, per the rider DRS, we need to have the customer establish a usage history for 12 months prior to them being able to receive DRS credits. So the contract with Cyber has indicated that they would have a 1 megawatt firm capacity. So we would just confirm everything after we have that 12-month history. So they would start in year 2.
So was that the reason why Cyber Innovation was willing to be interruptible during the first year? Or let me ask you this, why was Cyber willing to be interruptible during the first year of the contract? Why were they willing to?
It was something that we had discussed with the customer and that they had agreed to, knowing that they are able to interrupt, fairly quickly.
And who benefits from the service being interruptible?
All customers benefit from the service being interruptible because Rider DRS is a peak shaving product. So to the extent that we can shave the peaks, the cost would be lower for all customers.
And could you look at your next question there on page 4 that reads, why did the company enter into the proposed contract with Cyber Innovation? See that question next one?
I do.
Okay. And over on the top of page 5, the answer continues. And could you read that, that last sentence of your answer there, please?
The Long Fork EDR contract is virtually identical to the contract at issue in this case. Is that what you were referring to?
Well, it's
Or-
about that topic. It says Cyber Innovation is currently operating. It's
Oh,
similar-
okay.
You see that part? Yes.
Cyber Innovation is currently operating its similar but larger Long Fork facility under a commission-approved EDR contract, TFS 2022-00073. The Long Fork EDR contract is virtually identical to the contract at issue in this case.
Okay, thank you. So the two facilities are virtually identical, correct? That's your testimony.
That's correct. They're different sizes.
Okay. That
Load.
was my next question. Virtually is not exactly the same, so could you explain the differences between?
The Long Fork facility operates at a higher load than this one. This one is planning to operate at 7 megawatts. Boy, I can't remember what the other one is. It's like 15 or 20,
Okay.
maybe?
So fair to say it's twice the size, Long Fork is twice the size?
I would say roughly,
Okay.
yeah.
Right, okay, very good. And then, on that same page 5 of your rebuttal testimony, Mr. West, that very last question that says, does Cyber Innovation otherwise fully qualify for tariff EDR? Do you see that question there at the bottom?
Yes.
Okay. And on your answer, in line 2 of your answer, you refer to Attorney General Witness Stacy Sherwood. Do you see that?
I do.
Okay. I believe you meant to say the intervener witness, Stacy Sherwood, didn't you?
Yes, you are correct.
Thank you. Just wanted to get that clarified for the record. Thank you, Mr. West. That's all the questions I have.
Thank you.
No questions, Your Honor, thank you.
Mr. Smarr, Mr. Gary?
Yes, Your Honor, thank you. Good morning, Mr. West.
Good morning.
Can you start by saying what was your involvement with Kentucky Power's review and negotiation of the Rock House facility contract?
Well, this contract is based on current Kentucky Power tariffs. So they would start with IGS, tariff IGS. They would also participate in tariff EDR, and the customer agreed to be interruptible, so they would participate in rider DRS. So there really wasn't a negotiation per se. It's all straight tariff.
What was your personal involvement in reviewing and approving the decision that the company made to offer this contract?
Well, I reviewed the contract that we put together, and of course it references each one of the tariffs, and those are, on file with the commission-approved tariffs. I reviewed the language in the contract and, kind of back and forth with the customer.
Was there anyone else at Kentucky Power involved in this review of the contract?
Council was involved, as well as one of our engineers, I think, because of the size of this account. It's what we would call, I think, a managed account by one of our power engineers. And I'm not an engineer, so I need that kind of expertise to rely on, questions and things.
What is the current status of the project?
Well, they're operating, and I believe they've been operating at this location for approximately 12 months. They're not operating at full load. They're not operating at the 7 megawatts. I think they're in the 4 megawatt range.
In this case, there have been discovery responses concerning load up until January of 2023. Do you know if the load has increased since January 2023?
I do not.
Is it fair to say that over the last 12 months, the load at the site has been increasing?
I'm not sure, what are you referencing when you...
Well, you said that they're operating at 4 megawatts. Were they operating at 4 megawatts when they first started operating?
Probably not initially. I think they had to ramp up a little bit to get to that level.
And do you know if they've ramped up further since
I do not
January
know.
2023?
I do not know.
Is there any other witness here today that would be a better person to ask that question to?
No, there's not.
Your Honor, we'd request an opportunity to ask a post-hearing data request on this
That'll
question.
be fine.
Do you have any evidence that the facility would not continue to operate if the EDR contract were not approved in this case?
Could you maybe ask that one more time, please?
So you said they're operating at 4 megawatts currently, correct?
Roughly, yes.
And they've built the facility and they're operating at 4 megawatts without there being an EDR discount in place, correct?
That's correct.
do you have any evidence that they would not continue to operate if the EDR discount at issue in this case were not approved?
I do not have any evidence.
Do you have the discovery responses up there with you?
I do.
There was a spreadsheet that was produced as attachment 1 to the response to PSC 1-1. Do you have that with you?
You said that was KPSC 1-1?
Yes.
I do not appear to have that one.
There was both a public and a confidential version of that spreadsheet, but my intent is only to ask questions about the public version.
Okay, I'm sorry, I don't have it with me up here.
Ms. Glass, do you have a copy that you can provide the witness?
Yes, I do.
Thank you. Do you have the spreadsheet with you?
I do.
Maybe I should start by asking, are you able to answer questions about this spreadsheet? Is this something you're familiar with?
The better witness for this would be witness Khan?
And is Ms. Khan planning to testify today?
Yes.
She is, okay. Maybe I should save my questions then for Ms. Khan.
May I approach the witness to get the spreadsheet back?
You may.
Can you turn to the response to AG 1-23?
Yes.
And attachment 2 to AG 1-23 shows the company's current projections as to its capacity position. Is that right?
Yes.
Could you turn to the response to AG 1-4?
Yes.
And there's a discussion here of the cost to the company of purchasing capacity after the expiration of the Rockport UPA. Is that right?
Yes.
And so there's a discussion of whether the company would incur any additional incremental costs to purchase capacity. It says that it would not through at least May 31st, 2024. Is that right?
That's correct.
So it's my understanding that the company has now entered into bilateral agreements to purchase capacity beyond May 31, 2024. Is that right?
That's correct.
Which years have those agreements been entered for at this point?
They are for the next two PJM delivery years, so 24-25 and 25-26. The company has sufficient capacity to serve all of its customers. It has to purchase capacity to serve its customers after the expiration of the Rockport UPA.
And are you able to say what the cost of the capacity purchases under those agreements has been?
I don't recall off the top of my head what they are.
Do you recall whether they are more or less than the capacity that the company had been purchasing through the Rockport UPA?
They are less.
Your Honor, we would request the ability to seek a post-hearing data request on the capacity costs for those two PJM delivery years. Thank you, Your Honor. I'd like to ask you about the status of the company's purchase of a security bond. Well, first of all, tariff EDR requires that in the event of breach of contract or early termination of the special contract, that an EDR customer is responsible for paying back all EDR discounts. Is that right?
That's correct.
And I believe the Kentucky Power in discovery responses sponsored by you has said that Cyber Innovations Group has verbally agreed to post a bond. Is that right?
Yes, they have, and I believe I addressed that also in my rebuttal testimony. Should the contract be approved, that is.
What is the amount of the bond that they have agreed to?
I don't have that information in front of me, but it would basically be an estimate of the discounts that they would receive in the first 5 years.
Why was a bond not included as a written requirement of the contract in this case?
Well, it kind of arose, as part of this case. I believe we received some questions, some discovery questions about that possibility. So we discussed it with our customer, and they were agreeable to do that provision in order to, add an additional protection for customers. So it sort of, grew out of the filing of this case.
Does the company have any sort of written agreement with Cyber Innovations Group to post the bond, or is it just still a verbal agreement at this point?
I think it is a verbal agreement at this point. I don't believe there's anything in writing.
Mr. Horn asked you questions earlier today about rider DRS. And I believe there was discussion of whether the company would participate in rider DRS during the first year of its contract. Is that right?
That's right.
Since the company's been operating now for roughly a year without the contract, have they been participating in rider DRS over the last year?
Yes, they have, and they've been interrupted, and they have complied.
So they've been continuing to operate with, strike that, they've been operating with only 1 megawatt of firm load over the last year?
when they've been required to interrupt for 3 hours, yes, that's the level that they are supposed to drop to. So if they're at 4 and we call for an interruption, they are required to drop to 1.
Yes.
Yes, so I'm saying when they're interrupted, they would drop to 1.
How many times have they been called on to curtail in the last year?
Several, I don't have the number in front of me.
And are they being compensated pursuant to the provisions of Rider DRS?
Not until year 2.
So has this first year then counted as their first year to establish the 12 months of operating history that you mentioned
Yes.
earlier?
Yes.
And so if the commission were now to approve the contract, would they be at year 2 of Rider DRS and they'd be able to start being compensated?
Yes.
Those are all the questions I have, Your Honor. Thank you, Mr. West.
Mr. Bellamy?
Well, Mr. West, I'm Ben Bellamy. Just going back to your rebuttal testimony, you've already been asked about this, so I'm just gonna refer to it. But on page 5, line 15, your rebuttal testimony, you were asked if Cyber Innovation had complied with the requirements of the tariff EDR, and you just replied, yes, Cyber Innovation has met all the requirements of the company's tariff EDR, as well as the order and administrative case number 327. Is that correct?
Yes.
So are you familiar, I take it, with all of the requirements of tariff EDR?
I think so, yes.
Okay. In the contract that was attached to the letter, attachment 1 to the letter that was filed through the tariff filing system, I'm looking at section 4.9. It starts on page 7 of the attachment.
I'm there.
Okay. So customers have been provided a copy of the company's tariff EDR. Customer recognizes that during the term of this contract that Kentucky Power may be required to acquire additional capacity on behalf of customer. In the event the company is required to acquire additional capacity on behalf of customer recognizes and agrees that customers' IBDD may be reduced in accordance with paragraph 1 of the terms and conditions of tariff EDR. Under what circumstances, in your opinion, it says that they may be required, under what circumstances would they be required to, would the IBDD be reduced?
Well, as we explained in the cover letter, the company has sufficient capacity. Per tariff EDR, it says that the company has to have sufficient capacity and to enter into EDR contracts. And I don't believe in this circumstance that this customer would be required to, for their discounts, I mean, to be required to be reduced. Because we have a compliant plan on file with PJM, and we have enough capacity, whether it's owned or contracted for, in order to cover all of our customers' generation. Therefore, I don't, as we stated in our cover letter, we don't interpret this to apply.
When would it apply? When would they be required to I guess, reduce the IBDD?
If the company was, let's say, for some reason, we had filed an insufficient plan with PJM, and we had to purchase additional capacity, I suppose that might be a circumstance where that could happen. But again, it would not necessarily be that we would be purchasing for one singular customer. We would be purchasing for all of our customers.
So I just want to ask the question again. Under what circumstances would that tariff provision apply?
Well, as I said, if we had filed an insufficient plan with PJM, I suppose it's possible that that could apply.
But then you said, but even then, we would have sufficient capacity. So do you think it actually applies to that fact scenario, or do you not think it applies to that fact scenario?
I'm not sure that it even would in that scenario, because
Okay.
like I said, we have to purchase capacity. We don't, you know, it's not, all of our customers, we have to serve all of our customers, and we don't, you know, it's not like we identify every minute or every hour, you know, who's that one customer that, you know, makes us have to go purchase something.
Okay, so
That's not how it's done.
It's a very simple question though. You have a tariff provision that exists under this, that you have, when you have to buy capacity for your capacity insufficient, whatever the tariff provision says, okay? It has to apply to some circumstance. You just laid out a circumstance that you originally said it would comply with, and then you say it doesn't comply with it. So, under what scenario can you envision that that tariff provision would ever apply?
I think that you'd probably have to say if we had filed an insufficient plan with PJM, an insufficient capacity plan with PJM.
Okay, that's what you said earlier, but then you said it doesn't comply. So you now are saying that would be the fact pattern.
Yes,
Okay.
if.
Do you know what happens if your plan does not have sufficient, if you're short in your FRR plan?
If we file an insufficient plan with PJM, I think that there are penalties. I'm not 100% sure about that, but I thought that that was the case. Therefore, I don't know why we would ever file something that's insufficient with
Okay, but do
PJM.
you know how you make yourself sufficient? Are you aware that you can either be long or short? You can sell the extra or buy back?
Yes.
Have to buy the amount. So if you're short, you might get a penalty, but then you would have to end up buying the additional capacity through the base residual auction. Is that your understanding?
I think that's the case, but.
Okay, so
but
you're,
like-
under your scenario, you'd be buying capacity. So would you be, under your thought process of this tariff, would you ever be short, ever be insufficient?
Unless we were, you know, covered by the power coordination agreement with the other AEP companies.
Go ahead, Mr. Bentley.
So on tariff sheet 37-1, and this is cited, I think, in your letter, or in the cover letter, it says, and I think this is the provision that you're referring to in the contract, but Kentucky Power's tariff states, when sufficient generation capacity is not available, the company will procure the additional capacity on the customer's behalf. The cost of the capacity procured on behalf of the customer shall reduce on a dollar-for-dollar basis the customer's IBDD and SBDD. Is that the tariff language that you're interpreting when you're determining whether or not under the contract there'll be a reduction in the IBDD?
Yes, and I'm saying that the company does have sufficient generating capacity.
So that's what I was gonna ask. Your basis for your understanding of it, because the phrase is, when sufficient generating capacity is not available, your interpretation is that if you've gone to the market to buy the generation capacity, then therefore it is available, and you're meeting the requirement of the tariff. Is that your position?
Yes, the company, with previous questioning, I had said that we had contracts, we have bilateral contracts for capacity through those next two PJM delivery years. So we have sufficient generating capacity to serve our customers. We have a compliant plan within PJM.
You have sufficient generating capacity currently, as of today, through the term of the 10-year contract to serve both your projected load and the contract load.
Well, we're not it's very difficult to contract 10 years out, okay? You can't really do that. I mean, it's more, 1 or 2 years at a time. And within PJM, we're required to have a plan 3 years out, not 10 years out. So I can't sit here today and say that, we have it locked up for the next 10 years, because I'm not sure what our load will do over the next 10 years anyway. So if I put a number out there and contracted for it, I have no idea whether it'd be right.
How long was the Rockport UPA for?
I think it was 20 years.
So not one or not two.
It was a different kind of an agreement, I think, between us and Rockport.
Okay, what was the agreement for? Capacity and energy?
Yes.
Okay.
Yes.
How about a purchase power agreement? Have you ever heard of those?
I have heard of those, yes.
Do those ordinarily last more than 1 or 2 years?
They do.
So what is it that you're referring to when you say that these are done 1 and 2 year at a time?
I'm referring to the bilateral contracts that we did for 1 year at a time for each PJM delivery year. And what I'm saying is, I'm not a commercial operations expert, but during the negotiation of those, when we put those out, I remember some conversations like, you're not going to be able to go out and get a capacity contract for 10 years.
Who told you that?
I think it was one of our commercial operations people. It's just that nobody's going to give you a price.
So you ended
Not
up
knowing
doing,
anything about 10 years out into the future, they're not going to give you a price and lock it in today.
so you ended up doing 1 and 2 year deals or 1 or 2 year deals with affiliates, is that right?
They're third parties. For those two delivery years I mentioned, they're third parties. They're not owned
didn't
by or
get it-
affiliated with
You
AEP.
didn't do it through the bridge PCA, you're saying?
Through May 31st of '24, yes. But after that, '24, '25, '25, '26, those were contracts with third parties.
Go ahead, Mr. Bowman.
If this contract were approved, Cyber Innovations would get discounts on the demand charges. Is that correct?
Yes, that's correct. That's how tariff EDR works.
And are you familiar with what costs are typically recovered through the demand charges?
Fixed costs?
Would the fixed cost of Kentucky Power's existing generating assets be recovered through the demand charges?
In general, yes.
I believe in response to requests for information, you indicated that to the extent that there is a capacity purchase through a contractor through the market, that the cost of that would be recovered through the PPA rider. Is that correct?
That's correct. Purchase power is recovered through tariff PPA.
So the capacity costs, if Kentucky Power were to go out and get, additional capacity to serve, both their load and, any customers, including, Cyber Innovation, that capacity cost would be flowed through the PPA, is that correct, or the PPA rider?
That's correct.
Would the cost, would you determine a specific amount of, say, capacity cost that would be attributable to cyber innovation? You know, let's say, would you determine we had to get 7 megawatts, or I guess, let's say, if it's firm, you know, 1.1 megawatts of capacity, you know, to serve cyber innovations, would you then flow that cost directly to cyber innovations through the PPA, or would that be spread across to all customers?
No, we would not flow that directly through. As I said, we don't assign, you know, capacity cost to individual customers. As I mentioned, you know, if you want to get down to the details, the load varies every second, every minute, every hour.
Mm-hmm.
It could be one of our other IGS customers that has a blip at that particular hour, and it, you know, their capacity costs or capacity needs would rise. And like I said, if you want to get down to the details, you could assign it that way, but it's not done that way. We purchase capacity to serve all of our customers for 3 years out as part of PJM, okay? So we're covering all of them.
And I understand that. So to the extent that you're purchasing capacity through a PPA, you're flowing that through to all the customers through
That's
the
right.
PPA rider, correct?
That's right. That's how purchase costs are recovered.
Then, but to the extent Kentucky Power does own native generation themselves, correct?
We do, yes.
Okay, so the cost of that, the fixed cost of that native generation, that is typically, as you said, recovered through the demand charge, correct?
It's typically yes.
So in practice, the way that this would work is Cyber Innovations would be getting a discount on the fixed cost for Kentucky Power's natively owned generation. Correct?
In general, yes.
And other customers, to the extent that the cost of service study was conducted and accurately reflects the cost, they would be paying the fixed cost attributable to them through their rates, correct?
They should be, yes.
Okay. But then to the extent that Cyber Innovations is causing Kentucky Power to purchase additional capacity through a PPA, that cost is flowed through both to Cyber Innovations and to other customers. Is that correct?
As I said, the capacity costs are paid for by all customers. They're not assigned to any individual customer. When we you know, purchase capacity, we don't say we need this for that guy and this for that guy, and then they have to pay for that. That's not how it works.
I'm sorry, Mr. West. I still just want to go back to, then why does the tariff EDR explicitly envision purchases for customers taking under that tariff in the event there is not sufficient generating capacity?
And it's difficult for me to answer that, Mr. Chairman, because I wasn't here at Kentucky Power when this tariff was put into place. I don't know all the details behind modeling it, other than it was designed and I think based on the order in the administrative case 327.
It was, except that specific provision was sought by Kentucky Power as the maybe sole across the Commonwealth exception to Admin 327, is it not?
As I said, that is my understanding, but I didn't design it. I can't tell you like the details behind when it was designed.
Yeah, but you're telling us that on behalf of the company, that the practical implication of that tariff provision, which is frankly a tariff provision that reduces the risk to the rest of the system insofar as capacity purchases are necessary for that economic development customer, that provision in practice, and this is your testimony here, you can think of no factual situation in which that provision actually is implicated, right?
I think that earlier when you asked me about this, I did say that if we, for some reason, would file an insufficient plan with PJM, that would be a scenario where we would have to purchase capacity. But even in that scenario, we have to purchase capacity. It may not be just that 1 megawatt, it might be less than that.
Okay, then let me ask you this, Mr. West. Why does that provision even exist? So if that provision went away in your all's tariff, and the EDRs have to comply with Order 327, would you be able to offer an EDR right now?
The company is capacity sufficient, so I would say yes.
You believe that you have sufficient capacity that you can offer economic development. That's right?
Yeah, that's right.
You're a winter peaking utility, is that right, Mr. West?
Yes.
Okay. Do you have sufficient generating capacity owned or contracted for to meet your winter peak?
No, we have.
Mr. Bellamy, do you have any other questions?
I did.
Okay, please proceed.
I'm just looking at the response to joint interveners' second request, item 1. And this is partially confidential, but I'm not going to mention the specific confidential information.
I'm sorry, which one are you referring to?
Joint interveners' second request for information, item 1, and Kentucky Power's response.
Joint interveners 2-1.
Yes.
Yes.
And ask about the load for cyber innovation. It says current load is, and that's blacked out, I won't say, with a blank capacity, or with a blank load factor as of January 27th, 2023.
Yes.
And I don't need anything about the specific numbers, but how was that load factor calculated?
I believe it was calculated by our power engineer. I don't exactly know the calculation myself, but it was calculated by our power engineer.
Okay, I might just ask that as a post-hearing data request.
Sure.
Sort of as a follow-up, though, that you might know the answer to, is, there was some discussion about whether or not they were currently operating at 7 megawatts cyber innovations.
Yes.
Have they completely built out the system such that at peak it could take 7 megawatts? Or that the demand would be 7 megawatts? Or have they just not built out the system yet such that the current demand, or at least as of January 27, 2023, was below 7 megawatts?
You mean has the customer built out their system?
Yes, I apologize.
I think that there was a discovery response that talked about them needing to add a few things in order to get to that 7 megawatt number. So I don't know specifically if they've done that yet, or if they're waiting to see if this contract is approved before they would spend that additional capital.
You kind of indicated that you were in discussions with, or involved in the discussions with Cyber Innovations, when they were seeking the special, or the EDR. When did those discussions with respect to this facility first start? I know that they have another facility, but when did the discussions with respect to this facility first start?
I don't recall specifically. I think we filed this in November of last year. Usually takes a couple of months to put something like this together, so I'm guessing a few months before November.
And I don't need specifics. I mean, and I don't necessarily want to guess. I mean, do you have any specific recollection of the first time that this facility was brought to your attention by either someone that works with you or by Cyber Innovations?
No, I do not.
You don't have any kind of ballpark recollection even?
Other than what I just said about, in general, it takes a couple of months to put something like this together. So I'm guessing September-ish of 2022, perhaps.
I'm looking at response to staff's first request, item 2.
I don't have staff 1-2.
Oh, you don't? Let me see.
Not in front of me, no.
Just call, you have a-
Oh, okay, it was Amanda Clark responded to that. So I can ask her
Okay.
that question, I think.
Okay.
So, let me just double check this and make sure you weren't the one on this one. Okay, Amanda Clark, this one was for Amanda Clark too, I'm sorry.
Okay.
I'm looking at AG's, Kentucky Power's response to AG's first request for information, item number 5.
Yes.
You'll just give me a second, I apologize, I'm getting there. So this talks about the forecasted pool requirement for delivery year 2023 to 2024. In PJM, it says it's, 9.3%. And then indicates there's a total load obligation. The total load obligation would be 1.093 megawatts for cyber innovation.
Yes.
I wanted to refer to attachment 2 to AG's request 1, or AG's first, Kentucky Power's response to AG's first request, item 23. And it's a chart that has the full load obligation each year.
Which attachment?
Attachment 2 to
Okay.
Attorney General's first request for information. So it has estimated load obligation there near the bottom of that chart.
Yes.
And the first one is 1014.4. That is the PJM load obligation. Is that correct?
That is the estimated load obligation, yes, for Kentucky Power.
So that's the, essentially the capacity requirement for an FRR entity, or what you're estimating it will be for that year, or for Kentucky Power.
This is the, I'm hesitant to say that for certain. I'm looking at this and saying this is the forecasted capacity position for Kentucky Power.
I guess my question was, is the reserve, the 9.3% that's mentioned for the forecasted pool requirement, that's essentially the unforced capacity reserve margin established by PJM, is that correct?
That's correct.
When this estimated load obligation was estimated, what was the forecasted pool requirement that Kentucky Power used for the reserve margin to estimate this load obligation on attachment 2?
Well, I think that if that other response said for 23-24, then I'm not sure about 22-23 because that reserve margin fluctuates from year to year, it's my understanding. If that was for 23-24, then that 9.3 should be included.
That was sort of what I was wondering. Did Kentucky Power just estimate that the 9.3 would continue on throughout the 10-year period, or did they actually project like changes in the PJM reserve margin requirement?
I'd have to verify that.
Okay. I might ask that as a post-hearing data request then.
Sure.
If you could refer to your rebuttal testimony on page R5 at line 3.
Yes.
And you refer to the previous tariffs that are talked about there as commission approved. Are the tariffs that are discussed there, were those, or I guess the EDR contracts, were those specifically approved in an order, or were those permitted to go into effect without being suspended?
Well, I understand from our hearing last week that, the commission has some concerns about that. We filed them per commission direction in the tariff filing system. After we filed our first EDR customer, we were instructed afterwards to file the future ones in the tariff filing system. So we did that. We received the customary letter from the executive director saying that they were received and accepted, I believe was the language in there. So the company is operating under the assumption that they were approved. I don't believe we've ever expected the commission to issue an order on them. It's just like it's the tariff filing system, so we get a letter saying that it's accepted and received. So absent the commission issuing an order, we have nothing else to go on but the letter that says that they were received and accepted. So we've operated under the assumption that they were approved by the commission.
And I'm just, as a factual matter, I just wanted to confirm that that was the process that was followed, that it was filed through the tariff filing system and
As we were
accepted
instructed,
or allowed to go into effect through that process, but there was no specific order approving. That was all I was attempting to confirm.
that's correct. It's not to my knowledge, but we were following the commission's direction to file those contracts through the tariff filing system.
You were asked about Cyber Innovations agreeing verbally to enter into a bond. Would they be open to amending the contract in a way that would require that as part of the actual special contract?
I believe they would, yes. An addendum.
I just wanted to go back to Kentucky Power's response to Attorney General's first request for information, item 23, with those charts. I think when there was a discussion about the specific requirements of the tariff, you made a comment which you might have been meaning just in one specific instance, because I think elsewhere you testified differently, that Kentucky Power is not short on capacity. If you look there at attachment 2, it's showing short-term market purchases in 2022, 2024, 2025, through 2028. And those are short-term market purchases to ensure that you have sufficient capacity under the PJM requirements to meet the load obligation within PJM. Is that correct?
That's correct, and we're required to meet a certain obligation because PJM only requires that we have sufficient capacity for summer peak, not winter, summer peak.
I understand that. So this is based on the PGM capacity requirement, which is established based on the summer peak, correct?
That's my understanding, yes.
Okay.
That's our requirement.
But you would agree, even on this chart, there's, starting in 2028, 2029, it says, I guess, TBA, which I'm assuming means to be determined, IRP update driven solution, and then you've got like 700 megawatts starting in 2028. So with the current capacity that Kentucky Power has either natively or has purchased through bilateral contracts or with the market, starting in 2028, 2029, Kentucky Power does not have sufficient capacity to serve its expected load. Is that correct? Even to meet the summer capacity requirement for PJM.
That's being determined in our current IRP. The current all-source RFP that the company is putting together in order to fill that position beginning in that year, yes. So we are working on that solution right now.
But as of right now, you do not have the capacity, correct?
No, we do not, but we're working on it.
And you mentioned that those are based on Kentucky Power's projected summer load, and that's because that is when PJM peaks.
That's correct.
But Kentucky Power itself is a winter peaking system, is that correct?
Yes, and as part of our participation in PJM, that construct has benefited customers for decades with lower costs.
And I understand that. I guess, and I know this kind of came up at the last hearing a little bit, but, just a brief explanation. As far as the requirements in, KRS Chapter 278 with respect to the adequacy of service, is it Kentucky Power's position that by meeting the PJM capacity requirements for the summer peak that they've satisfied any capacity requirement for, or any capacity requirement established pursuant to KRS Chapter 278?
I am not an attorney, but it's my understanding that yes, that is the company's position, that we are capacity sufficient and that we meet those requirements.
I might ask a poster
I'm
and
sorry.
gather question.
I just want to clarify, what do you mean, you used a pronoun there, those requirements?
What he was referring to, I have not read KRS, I don't remember the number.
You didn't see the filing in response to the commission order that Kentucky Power filed on Friday?
Yes, I read it.
Okay, well, it specifically cited that statute, so you're.
I understand that, sir. I just don't remember the exact number of what he just said or what I read last night.
Well, I guess what I'm trying to make sure of is, you said that you believe compliance, you said those requirements, and what I want to make sure I appreciate, are you referring to the requirements under state law? Or are you referring to the requirements, the FRR plan that PJM operates under FERC rules?
I'm referring to both. I think the company is providing adequate service to our customers, adamantly. I believe that.
Okay, but an adequate service is a statutorily defined term. And what I want to make, what I think Mr. Bellamy is asking is that the company's position that meeting its FRR plan approved under FERC rules, de facto, like by definition, when you meet that plan, you are by definition providing adequate service under state law.
I believe that is the case. I would refer to the filing that we made on Friday as the official record.
And I think, I know this has been asked in other cases and there has been other filings, but I think as a poster and data request, just, for the record of this case, I'll ask kind of a follow-up about compliance with PJM requirements, satisfying the adequacy of service requirement under state law. And I don't have any other questions.
Yes. Mr. West, can you hear me
Yes.
okay?
Yes.
I know that plastic barrier is a detriment to us being able to hear one another, so please let me know if you can't hear me okay.
Sure.
I'll move my microphone a little closer. I keep hearing from your testimony that Kentucky Power has sufficient capacity to meet its native load as well as the requirements of this EDR for capacity. But as I read the order in case number 327, it requires excess capacity in order to enter into an EDR. Do you feel that Kentucky Power has excess capacity?
I would refer to our tariff. The tariff says sufficient generating capacity. And the tariff is approved and compliant with Order 327.
So you don't think that EDR should only be offered in times of excess capacity? You don't think that's the law?
I didn't say that. I said that our tariff says that we have sufficient capacity. And I guess the point that I'd like to make is that, and this is a point that I made in the EBON hearing, that, without the company being able to offer contracts like this, we can't attract new customers to the area, to Eastern Kentucky. We can't grow our customer base and grow our load. Costs are not going to go down. They're going to go up. That's a fact. Things are more expensive all the time. And it would be beneficial to our customers if we had more load and we had more customers, that those costs could be spread over.
Okay, and I'll ask some more questions about that in a minute, but in your rebuttal testimony, page R6, the second sentence of line 13, your testimony says, Kentucky Power finds itself in a capacity short position after the expiration of the Rockport UPA and must contract for capacity to serve all its customers. How is that consistent with telling us that you do have sufficient capacity
Well,
and even excess capacity?
at the instantaneous moment when the UPA ended, you could say we were short, but we contracted for that. And, we traded one contract that expired for another contract. So the position before and after is really no different. In
So-
that we had sufficient capacity before and we have sufficient capacity now.
So it seems to be present tense as of the date of your testimony, but you meant that to be past tense?
I meant that to be past tense.
I know that your IRP mentioned that you plan to build some capacity, perhaps at the Big Sandy plant area. Do you know of any firm plans that Kentucky Power has over the next 10 years, since we're looking at a 10-year contract, to build any new generation?
Well, that's a subject for the IRP hearing for sure, but the RFP that we're working on right now, an all-source RFP, and that was mentioned in the IRP, that the company would be working on that and putting that out. I mean, we're planning to get that out very soon. And the results of that would help us, would help inform the different capacity options that we're looking at, whether that's wind, solar, a gas CT, a gas CC, and the results of that RFP will help firm up those plans that you're asking about.
Okay. So no firm plans as of this.
At the present time, no, we do not have a contract to build something in 10 years or 9 years or 8 years. That's the purpose of the RFP, is to inform that process, get the quotes from the vendors, the contractors, and then firm up a plan.
So we have been hearing for years that the only way to get costs and rates and bills with all these riders for your customers under control is to increase economic development and spread those costs. But as I hear you testifying today, it does not appear that there's a dollar-for-dollar flow-through for the excess capacity that you would have to purchase for this customer. Is that right? It would be spread to all customers if you have to pay a higher cost?
Yes, what I'm saying is the capacity purchases are recovered from all customers through tariff PPA, and I don't see us filing an insufficient plan with PJM that would cause us to have to reduce this on a dollar-for-dollar basis.
So I keep hearing that these savings are going to be spread to all customers, but then the evidence I see is just that these costs are going to be spread to all your customers. You have a current contract in place with this company, Cyber Innovation, is that right?
We have a contract that's not yet, that's right, we're talking about it right now. It's
Right, but
not commission approved yet.
There's one that's operating.
We have a contract for IGS, yes.
Okay. What benefits have your residential customers received from the current one that's in place? Are we going to see that in your current rate case, that the margins have been improved because of this economic development?
That's a rate design question that would be better answered in the rate case.
So we're being asked to approve this contract, and we're being told that it benefits your customers. Can you point to a way?
Well, I guess one thing I could point to is, this is the order in 327, where it says, at page 6, revenues received from EDRs that exceed variable costs contribute to a portion of the utility's fixed costs that otherwise would have been paid by non-participating ratepayers. This contribution results in lower costs for all ratepayers as utility fixed costs are spread over a larger total load.
But if you're incurring new fixed cost and then spreading those over customers, how does that help them?
They would be less than they would be otherwise, is the best way I can answer that.
And we should see that in the new rate case.
What are you asking?
We should see evidence of that in the new rate case, is what you're
Evidence
telling me.
of?
That customers their costs have decreased.
I'm not sure that you're going to see evidence of that in the rate case.
So as far as this contract, you said there is a verbal agreement to enter into another bond. I think we heard something similar in last week's case. What additional protections or collateral are there in writing in this contract to provide protections against if this contract goes belly up?
Well, The two that come to mind in writing are in the tariffs. In tariff EDR, there's a clawback provision on the discounts that they receive. That's also related to the surety bond that you're asking about, but it's in writing in the tariff. Also in tariff DRS, there's a clawback provision of the credits that they receive for interrupting, should they not interrupt. Now, besides that, they pay for all costs up front. If they have to make, improvements for their operations, company's not paying for that. And they are paying a deposit to cover their electric use, and I believe it's 2/12 of their annual usage calculated at a non-discount rate, so a straight tariff rate.
That's the standard
It's a
deposit.
standard deposit, that's correct. So those things coupled with the surety bond protects the customers.
And then, in your rebuttal testimony on page R7, we're told that there is very little additional capacity needed, because even though it calls for 7,000 kilowatts, 6,000 of that is interruptible and only 1,000 is firm. Do you think that the other party of this contract, Cyber Innovation, expects that they're not going to be able to use more than 1,000 a month? I mean,
No, the 1,000 only applies at times when we call for an interruption. So if they operate at 7 and it's, really hot and we expect that to be one of the 5 coincident peaks, we call on them to interrupt. They interrupt for a period of no longer than 3 hours at that point. It can be extended to 6 hours on that one particular day, but they would need to drop down to 1 megawatt. And after the interruption event is over, they can go back up to 7. So the vast majority of the year, they would be operating at their peak, their 7 megawatt peak, and only when we call for them would they drop to 1. So they're not operating at 1 most of the time.
so that's only in exceptional circumstances.
Well, it's when we call on them.
But your testimony is that really it's only 1,000 kilowatts firm, so there's not much excess capacity that's needed, but it's only going to be in extraordinary circumstances that they would need less than the 7.
But because they've agreed to be interruptible, we only have to supply and purchase their firm level, the 1 megawatt, not the 7, the 1.
I understand. But when we're saying we need very little excess capacity, it sounds like it's counting on needing to interrupt them constantly, and I just wonder if this company knows that.
I guess I'm still not following your question, I'm sorry.
It's just a matter of, it does sound like that this company expects that they're gonna have 7,000 kilowatts that's available, but then you're telling us really it's only 1,000 firm.
It's only 1,000 firm, but that's what we have to contract for with our FRR plan with PJM, is we have to contract for firm when they're interruptible. That's the way it works.
I think that's all the questions I have.
Corey, Mr. West, just to follow up on something you said just before this, that you're looking to attract customers, correct? You're looking to
Yes.
attract businesses to come here.
Yes.
So I'm going to ask you a very simple yes or no answer. Knowing what happened with FTX.
With
are you-
what?
With FTX going belly up and the cyber innovation, are you comfortable that Cyber Innovation is a company that will be here for the long run?
Yes.
Okay, thank you.
We'll take a short recess. We'll come back at 10:45 and continue with Mr. West. back on the record in case number 2022-00424. Mr. West, how long have you been in your current position?
Since February, well, no, since January of 2021.
Are you aware of a facility called Big Run in Eastern Kentucky?
Yes.
Are they a customer of Kentucky Power?
Yes, they were our first EDR contract, I believe.
Okay. You're generally aware of that EDR contract, I assume?
Generally, yes.
And the case that led to it? Approval of it?
Generally, yes.
Okay. I'd like, Mr. Bellamy, do you mind to bring up that application in that case?
Yes.
Okay. You mind to scroll up just so we can see the top? So this is the link to the commission's website. This is actually the, I think this is the PDF viewer of the webpage, right, Ben? Right, Mr. Bellamy?
Yes.
Yeah, so this is the actual link to the commission's website. We could scroll it to the top and see that just for a second. This is the application in 2018-378. If we scroll down just for a second, you'll see this is the application of Kentucky Power for that EDR. And then at the bottom of the first paragraph, the company specifically requests a deviation from finding number 5 of the commission's September 24, 1990 order and admin 327. Do you see that?
I do.
Have you, even in passing or in the past, seen this application?
I'm sure I have. It was filed prior to me coming to Kentucky Power in 2019.
Okay, but I take you're familiar with it. If you go to paragraph 3, Mr. Bellamy, it notes that the commission approved a tariff EDR in 2014 for Kentucky Power, and well, I guess approved it in 2015. The company asked for it in 2014, and as you noted earlier, this was the first contract executed pursuant to the tariff EDR. Is that right?
That's my understanding, yes.
Okay. So, if we scroll down, Mr. Bellamy, to page 5 of the document, and there's a heading that says compliance with administrative case 327 order. Do you see that?
Yes.
Okay. And it walks through, if Mr. Bellamy can slowly do it onto the next page, it walks through the individual findings within admin 327. I took from your response earlier to Mr. Bellamy that you're generally aware of that commission order. There are a number of findings that an EDR has to comply with, right?
Yes.
Okay. It walks through 3 and 4, and then it gets to finding number 5. Do you see that? Just wait 1 second.
Yes.
Okay. Finding number 5 requires that economic development rates should only be offered during periods of excess capacity. Do you see that?
I do.
Okay. Do you see the rest of the paragraph that says the commission required that upon submission of each special contract, utilities should demonstrate that the load expected to be served during each year of the contract period would not cause the utility to fall below a reserve margin that was considered essential for system reliability, and that such a reserve margin should be identified and justified with each special contract filing. Do you see that?
Yes.
Okay. Then paragraph 20 goes on to talk about the surplus as a result of having the Rockport UPA, and that you expect to have a surplus through the 21-22 PJM planning year, which ends May 31, 2022. And then the company's own word says, in other words, the company expects to have a capacity surplus beyond its PJM installed reserve margin for the first approximately 3.5 years of the discount period under the special contract. Did I read that accurately?
Yes.
Okay. And if we can go on to paragraph 21. Paragraph 21 says, based on current projections, which include the potential addition of significant new load unrelated to Big Run in the next few years, Kentucky Power expects that it may not have sufficient capacity to serve its then existing load beginning in the 2022-2023 PJM planning year. The company expects to fully address its resource needs in its next integrated resource plan filing in December of 2019. Is that right?
That's what it says, yes.
Okay. Kentucky Power did not have sufficient capacity to serve its existing load starting in the past delivery year. Would you agree?
Which delivery year are you referring to?
The past delivery year there on the page, the 22-23 PJM planning year.
I would not agree. Kentucky Power has sufficient capacity. We've contracted for sufficient capacity, and we have a compliant plan with PJM.
Okay. So the statement that you said was a past tense to the vice chair earlier was not correct.
No, what I said to the vice chair was that at the instantaneous moment that the UPA expired, we purchased capacity to replace what we needed. So one was a contract, the second one was a contract. It's really no different from one to the next.
Okay. So let me make sure that I have an appreciation for your worldview on this, Mr. West. As long as you're a member of PJM, and as long as PJM has enough capacity, whether you procure it to finalize your plan or they procure it for you to round out your plan or to make you a BRA participant, as long as PJM has adequate capacity, Kentucky Power has adequate capacity?
We rely on the PJM construct. We have owned generation, we have contracted for generation. What we cannot generate in energy, we purchase from the market. This construct is prudent. It has been a cost savings to customers for decades.
But none of those are relevant to what we're talking about here, Mr. West, right?
How are they not relevant? I don't understand.
Well, whether the PJM construct results in savings or not is not relevant to whether you have sufficient capacity. Well, let me ask you this way. It's going to form a question. How is the PJM capacity construct relevant to you having sufficient generation capacity as a utility?
Because we can rely on PJM's vast resources during winter when we peak. We're required to have that capacity to serve our customers during the PJM summer peak. That's the requirement in PJM,
Okay.
and we comply with that.
Let me ask you this. Under this sort of theory of the case that you've got going on here, if you had no generation, you owned no generation at all, okay? Couldn't participate in your FRR plan. PJM procured adequate generation to meet your needs. Do you believe under tariff EDR you would have sufficient generation?
Yes.
Okay. So let me go back. So you said the statement here says you would fully address your resource needs in the 2019 IRP. Did you?
I believe we executed what we said we would do in our 3-year plan, yes. I don't have it in front of me.
Okay. Let me just ask this. You state otherwise in this case that you're going to address, and in your responses to the vice chair earlier, that you're going to address your future resource needs in the 23 IRP. So did you address them in the 2019 IRP, or are you going to address them in the 23 IRP?
I think they're addressed in both of the IRPs, sir.
Okay. So in paragraph 22, the application by Kentucky Power says, in any event, referring to paragraph 21, I assume, given the relatively modest size of Big Run's contract demand, the company does not anticipate that it will be necessary to make a specific market purchase to cover the new Big Run load. Nonetheless, Kentucky Power has the ability to make bilateral purchases to meet the needs of an EDR customer during times when excess capacity may not exist. If we could scroll down, Mr. Bellamy. Moreover, tariff EDR includes provisions to address a specific market purchase if needed. Specifically, when sufficient generating capacity is not available, the company will procure the additional capacity on the customer's behalf. The cost of capacity procured on behalf of the customer shall reduce on a dollar-for-dollar basis the customer's demand discount. You can scroll down just a bit more. Such reduction shall be capped so that the customer's maximum demand charge shall be the non-discounted tariff demand charge. For these reasons, Kentucky Power requests that the Commission recognize this arrangement as an immaterial variance from Administrative Case Number 327 Order Guidelines concerning when a tariff EDR contract may be in place. Paragraph 23. Kentucky Power respectfully requests a deviation from finding number 5, which the Commission originally intended to address a concern that load served under discounted rates should not create a need for new plant capacity. The electric industry has changed significantly since Administrative Case Number 327 order was issued in 1990, with the developments of wholesale energy and capacity markets and the advent of regional transmission organizations that allow utilities to increase the use of market purchases and diversify resource portfolios. Let me ask you a very quick question. You claim that you'll have to purchase 1 megawatt of capacity to serve this new EDR load, assuming that you all are able to correctly identify the peaks in which costs will be allocated and disrupt the customer under DRS, right?
It's included in our plan, yes.
Okay, the 1 megawatt is all. Okay.
Yes.
Absent this agreement, would you all purchase that particular 1 megawatt?
Well, 1 megawatt in the context of our total load is kind of a rounding error when you're looking at 1,000 megawatts. So we would have sufficient capacity.
I don't know that that's an answer to the question. Would you have to procure the additional megawatt plus a reserve margin for that megawatt if you didn't have this particular load?
We may have other load that is required, and we'd have to purchase it. It's undetermined.
It's not undetermined. Counterfactual. Everything is the same between these two. You have this contract under EDR, you don't have this contract under EDR. The difference between those, does one of those include purchasing a megawatt for this contract and the other one not include purchasing a megawatt for that contract? That's a difference, right?
That's a difference, and if that load was included in our forecast, then it would be included in the capacity purchase.
Okay. I appreciate that. If it's not a customer, it will not be in the load forecast. Would you agree?
They still could operate absent the contract.
They might, but if they're not in the load forecast, you would not have to purchase for them. Would you agree?
I would agree that if they're not in the load forecast, but if they're an active customer, regardless of whether there's an EDR contract in place, they could be participating in rider DRS, which is a commission-approved tariff, and we would have to purchase and include them in the load forecast.
Okay. You noted earlier in response to Mr. Bellamy that you're generally aware of and have reviewed tariff EDR. Is that right?
Yes.
Okay. Mr. Bellamy, you want to bring up tariff EDR? Okay. So I asked you the question earlier, but in the context of the cross-examination, do you see the terms and conditions of tariff EDR?
Yes.
Okay. First term and condition, tell me if I read this wrong. The company will offer the EDR.
Sorry.
Okay. The company will offer the EDR to qualifying customers with new or increased load when the company has sufficient generating capacity available. Do you see that?
Yes.
Okay. When sufficient generating capacity is not available, the company will procure the additional capacity on the customer's behalf. Do you see that?
Yes?
Okay. Is the capacity that you get through the bridge PCA generating capacity?
Yes?
Are you entitled to energy from those specific units for which you've contracted capacity under the bridge PCA?
No. We rely on the market construct. What we do not generate, as you know, it's all sold into the market, and then we purchase back 100% of the energy needs that we require for our customers.
Okay, do you get the benefit of the energy sold by those generating units that you've contracted capacity with?
I believe any benefit, if you're referring to off-system sales, are...
No, I'm referring to
No.
the exact economic scenario you just described. That your generating units produce energy for which you sell into the market, and then you buy back what your hourly or 15-minute demands are, right? Okay, that capacity that you've contracted for through the bridge PCA, do you get the benefit of the energy that those units sell into the market?
I believe it's included in the monthly FAC filing.
So I'd like to ask a post-hearing data request for you to show me where you get the economic benefit of that energy that's sold by the generating units that you have the capacity right through the bridge PCA.
Okay?
So then it goes on to say the cost of capacity procured on behalf of the customer, again, this is the customer that came on when you don't have sufficient generating capacity, shall reduce on a dollar-for-dollar basis the customer's IBDD and SBDD. Such reduction shall be capped so that the customer's maximum demand charge shall be the non-discounted tariff demand charge. Okay, so we've now talked about what your own application said in 2018 under the first EDR. You've got the benefit of hindsight a little bit, right? What do those first few sentences mean?
In my mind, it means that if there is a scenario where we do not have sufficient capacity, which I cannot hardly envision, that we may have to purchase capacity for an incremental load.
Okay. Are you buying capacity for Big Run?
We're buying capacity for all of our customers.
Yeah, okay.
We don't do it just
Is that
because
a yes
one
or
or
no?
another.
Are you buying capacity for Big Run?
Yes, and for all of our customers.
Are you passing through to Big Run as a reduction to their demand, to their IBDDs, the cost of that capacity on a dollar-for-dollar basis?
Are we reducing their discounts? No.
Okay. Do you mind to pull up the final order in that 2018 case?
It just takes a second to
That's
catch
fine.
up.
So this is the final order in 2018-378, the application that we looked at earlier, Mr. West. On page 8 of that order in the commission's discussion, which starts on page 7. If we go to page 7, Mr. Bellamy. So on page 7, you go just a tad, it says, having reviewed the record and being otherwise sufficiently advised, the commission finds that the proposed special contract is reasonable under the particular facts presented. The commission further finds that the special contract substantially complies with the provisions of Kentucky Power's tariff EDR, and that the EDR requirements established in Admin 327. Regarding Kentucky Power's request for a deviation from the following requirements of finding 5 of Admin 327, quote, EDR should only be offered during periods of excess capacity. Utilities should demonstrate upon submission of each EDR contract that the load expected to be served during such year of the contract period will not cause them to fall below a reserve margin that is considered essential for system reliability, end quote. The commission finds that Kentucky Power's request is reasonable and should be granted. Did I read that correctly?
Well, I can't see it,
Oh.
so
Sorry, I've taken some.
I heard you, but
Okay.
I
That's
couldn't
fine.
see it.
That's fine, we'll let it.
Yeah, okay.
Okay, so then the order walks through, as you can see there, talks about the capacity deficit that will occur beginning in the 22-23 planning year. Now, Mr. Bellamy scrolled just for a second. And that the discount period would end in the middle of 24 based off the proposed special contract, and thus Kentucky Power would have sufficient capacity. You can see that part, right?
Yes.
Would have sufficient capacity during the majority of the 5-year discount period. Talking about the reserve, and it goes on to talk about the reserve margin. It appears that the anticipated termination of the Rockport lease agreement and the associated 392 megawatts in 2022 is the primary factor in causing Kentucky Power to become short in capacity at the end of 2022. Do you see that?
Not exactly, I
Well,
think.
give it just a second.
It's about 20 seconds behind, I'm sorry.
That's okay.
Struggling here.
Do you have a copy of that order?
I do.
Do you mind to provide a copy to maybe Mr. Horn and Mr. Bain can shoulder up and share one? Okay. And make sure that Ms. Glass has a copy as well as the.
I'm looking at one online. I'll
Okay.
need a copy, thank you.
Thank you.
Make sure that. All right, and so that what I just read is on page 8.
Okay.
Okay, so page 8, the 5th line down, it talks, the commission says it appears, and it goes on to talk about that Kentucky Power will become short in capacity at the end of 2022. You see that?
I do.
Is that, do you believe that the commission was wrong in its anticipation?
To the extent that that expires, as I said, when it expires instantaneously, you could say we were short capacity. But we've replaced that with contracts that are, by all intents and purposes, the same as contracting for capacity through the Rockport UPA.
Okay,
So there's no difference.
okay. So then you go, the order goes on to say that Kentucky Power asserts that its capacity shortfall will be addressed in its integrated resource plan filing later this year. We further note that Kentucky Power's average forecasted load from 22 through 29, or during the period of time that Kentucky Power is projected to be capacity deficient, is in a capacity deficit, is approximately 1,101 megawatts. Big Run's capacity demand of 3.6 megawatts accounts for only 0.3% of Kentucky Power's total load obligation over this time frame. Okay, do you see all that?
Yes.
Okay. Do you mind to read the next paragraph for me?
Given that Kentucky Power will be addressing its future capacity shortfall in its upcoming IRP filing, and that the Big Run load would not have caused or exacerbated Kentucky Power's future capacity deficit, the Commission finds that Kentucky Power's request to deviate from the requirement that it have sufficient capacity before offering the EDR discount to Big Run to be reasonable. Lastly, we note that Kentucky Power's tariff EDR includes a provision that permits Kentucky Power to purchase capacity on the EDR customer's behalf when the company does not have sufficient generating capacity. The provision provides that costs associated with the capacity procured on behalf of the EDR customer will reduce on a dollar-for-dollar basis the customer's demand discount. To the extent Kentucky Power is required to purchase capacity for Big Run, those costs would be borne by Big Run.
why are you not passing through the cost of capacity purchases to Big Run?
Because we purchase capacity for all of our customers and don't assign them to specific customers.
Are you saying that that's beyond what the commission envisioned specifically in this order, that you all were gonna just not purchase capacity for other customers?
I guess what I'm saying is that it negates the entire purpose of offering a discount to customers. If we want this service territory to grow, and we want load, and we want to spread costs over larger load and more customers, you can't do that without offering something. You have to entice those customers to come here. And what they're looking for, and I'm not talking about Big Run, I'm talking about larger customers, I'm talking about economic development here. As I said last week in the E-bond hearing, we've got nothing to offer without this. And what we're asking is, we don't think that we are capacity short. We are capacity sufficient to offer these contracts. We can actually, per our tariff, offer them even if we're not sufficient, but we are sufficient. And what I'm saying is you're going to cut the legs off this company if you do not see this the way I'm saying it.
If I don't see it your way, we're undermining the company. Is that your response?
What I'm saying is that we have nothing to offer these customers, Mr. Chairman,
Let me ask it this way,
without
Mr.
offering discounts.
Yeah, let me ask it this way, Mr. West. You're offering a discount on something that's costing you money, right?
It is costing the company money and the customers money, yes.
And is the amount that you're selling it for more or less than what it's costing you?
I'm not exactly sure. I'd have to look at the analysis.
Oh, well, that's a pretty big question.
It's a pretty big question, but we are required to provide marginal cost analyses on these customers. We file them with this commission every year.
Okay. And the marginal cost analysis that you filed with this included capacity costs?
I'd have to look at it. I don't remember if it did or not.
Well, so I guess what I don't have an appreciation for, Mr. West, is how, if you're buying something and then selling it to someone for a price less than what you paid, and you're recovering the difference of that from other customers, how that is arguably reducing other customers' gross costs.
I guess I would go back to what I read before from Order 327. Revenues received from EDRs that exceed variable costs contribute to a portion of the utility's fixed costs that otherwise would have been paid by non-participating ratepayers. This contribution results in lower costs for all ratepayers as utility fixed costs are spread over a larger total load. These are the commission's words.
That's right. But it's important and imperative to those words. Let's take a step back. Those words assume that you calculate a marginal cost analysis that takes into account the variable cost of serving the new load, correct?
I believe so, yes.
And if you are having to purchase capacity to serve the additional load, there is a cost to that, correct?
There is a cost to purchase capacity for all of our customers, yes.
Answer it however you want, that's fine. Absent the additional load, the load forecast would be lower, and you would not have to purchase capacity for these EDR customers, correct?
If they're not included in the load forecast, then yes, we would not be purchasing that incremental piece.
And so by definition, that capacity purchase is a variable cost of serving the incremental demand. Would you agree?
Mr. Chairman, I don't think we're ever going to agree on this.
You can answer the question, you cannot answer the question, but do you agree with that statement or not?
Can you repeat that statement?
Sure. Okay. If there is I'll ask it this way. If there is a incremental cost of serving this additional demand, that variable and incremental cost should be included in a marginal cost analysis. Would you agree?
I believe so, yes. I think we've included it. As I said, I don't have it in front of me, and I can't verify that.
Okay. So let's take a big step back. Let's say you all had an extra, let's say this was 5 years ago, 6 years ago, okay? You had excess capacity. Do you agree that that's general, I mean, you generally had at least an extra megawatt sitting around. Would you agree?
I would agree.
Okay. In terms of capacity, what benefit was that extra megawatt? Did that cost you year to year anything additional?
Whatever was in excess would have been off-system sales that would have benefited our customers.
Okay, maybe, but that's an energy benefit, right?
Yeah,
Not a capacity benefit.
I believe so.
Okay. So if you had an extra megawatt sitting around, you would have excess generation. Is that fair enough?
We would have excess capacity.
Okay. And if you brought somebody in under tariff EDR and gave them a discounted tariff rate, and basically the extra megawatt cost you nothing, but you're able to get revenues from tariff EDR, the revenues from under that customer's 1 megawatt demand would reduce the cost for other customers. Would you agree?
Yes.
Okay. You're in a different situation now where you have to purchase each and every excess megawatt that comes onto the load. Comes onto the system. Would you agree?
We have to purchase capacity to serve all of our customers, yes.
Why would that provision in tariff EDR then not, let me take a step back. Finding number 5 says you should only do EDRs in times of excess generation. Would you agree?
Yes, but there's a provision in our tariff that allows us to offer it regardless.
That's fine, but that tariff approval was an exception to finding number 5, right?
Yes.
Okay. Why do you think that finding number 5 exists? Actually, let me ask you this way. Is it reasonable to assume that finding number 5 exists for the exact reason that you read a second ago? About the variable cost, as long as they cover variable costs, that ultimately that whatever they contribute in excess of variable cost benefits the entire remaining part of the system.
I think that's fair.
Is that your takeaway from it?
Yes.
Okay. So you, the company, sought a deviation from that requirement, correct?
In this contract,
No, in
You
the
mean-
tariff. In the tariff. You sought a deviation from number 5 in the tariff.
I believe so, yes.
Okay. And the commission here in 2018, in approving your first one, pointed to that tariff provision when discussing when the utility no longer has sufficient generating capacity to meet its load and has to buy capacity. Would you agree?
I believe that's what they were referring to, but we do have sufficient capacity.
You told me a minute ago that you did not have sufficient capacity to meet your native demand.
When did I say that?
I asked if you were a winter peaking utility. You said yes. And I said, do you have sufficient generating capacity, or sufficient capacity, I think is actually what I asked, to cover that winter peak? And you said no. Was I wrong in taking your response that you didn't have sufficient capacity to meet your native demand?
The company in the PJM construct is required to have a compliant plan for the summer peak because PJM is summer peaking. We do not have enough requirement for winter, but that's the beauty of PJM and the construct is we rely on the market, we rely on the megawatts that PJM has in total to be able to cover that for our customers at a lesser cost. It's kind of like the snowplow example that I gave you last week at that hearing, that if a, a community is required to have enough snowplows and salt sitting around for a once-in-a-lifetime snowstorm, how is that beneficial to that community to have all of that sitting around doing nothing until the 100-year storm comes along? It's the same thing here with winter capacity, that it would be a tremendous cost to our customers.
I'm sorry, Mr. West, are you trying to compare your annual winter demand to a once-in-a-lifetime storm?
No, I'm saying that our winter demand, because we're winter peaking, is higher. But the construct that we participate in through PJM, where we have sufficient capacity for the summer and we rely on PJM for the wintertime, has benefited customers tremendously.
That's a fine assertion, but it doesn't answer the question that was originally asked, is do you have sufficient generating capacity to meet your native peak?
The winter peak?
Yeah, the peak.
The peak.
Winter peak, summer peak, spring peak, April peak, the peak.
And I believe I answered no, but what I was starting to say after that was that what I just said. We have sufficient capacity, we have a plan with PJM, that's the requirement, is to have a plan that covers your summer peak. That's what we have. We rely on the market for everything else. It is a benefit to customers, it has saved customers money.
What analysis are you depending on when you say it has saved customers money?
I don't know that there's a specific analysis that I'm referring to. I'm referring to, my experience with the company, conversations that I've had with many people.
So it's your opinion that it saves customers money. It's not based off of any determination of whether that's the case or not. There's no documentary evidence that Kentucky Power customers are better off under the scenario you explained of how you envision the company having sufficient capacity through its PJM planning being best for customers than some counterfactual.
I think there is evidence provided in the response to the show cause order. I think there is evidence provided in the company's current base case.
So when you read in your tariff sufficient capacity, that in your mind means a compliant fixed resource requirement plan with PJM under FERC tariffs.
Yes.
What's your support for that belief?
It's my understanding that that's what's required for PJM, and we are a PJM member. We participate with the other AEP operating companies in the FRR plan, so it's my understanding that that's what we have to do. So we comply with it.
I get that, but sufficient generation is not in your tariff defined anywhere, right?
I'm not aware that it is.
Okay, but you ascribe that definition to it, right?
In my mind, that's what it means.
Okay, yeah, but what have you seen, what have you read that gives you the belief that that's what it means? I'm trying to have an appreciation for why you think meeting the PJM FRR plan equates to sufficient capacity under a Kentucky PSC tariff.
I guess I would just go back to that's what the PJM requirement is. That's my understanding. That's what the PJM requirement is. That's what we comply with.
I just want to make sure to round out the statement you made, the line of question I had earlier. Given that line that you keep reading from the admin 327 case, do you believe that an accurate marginal cost study is imperative to ensure that other customers benefit from EDR tariffs?
I believe that something like that, yes.
Okay, because you say that as long as the contract covers the variable costs, other customers benefit. That's basically what that provision reads, right?
Well, and that's what the commission said in that order, yes.
Yeah, but so determining what the variable costs are is imperative to figure out how or if other customers benefit. That's why I'm trying to make sure.
Yes, sir.
You agree with that?
Yes, I agree with that.
All right. And then finally, you kept using the word direction earlier in discussing the way you filed this tariff filing, that you did it, under the commission's direction or the directive that was required by the commission to file it through the tariff system. Do you remember that?
I do.
Okay. Do you remember what the commission said in that regard in that 2020 order?
Which 2020 order do you mean? The
one that you were referring to as providing a directive.
Well, to be honest with you, I thought it was in the,
Maybe the 2019.
I thought it was in the big run order, but I distinctively remember when that was approved, I distinctively remember some language that said that future EDR tariffs should be filed in the tariff filing system.
So can I ask Mr. Bellamy to bring that order, or you have a copy of that order? That's great.
I do, but
So page 9 of that order.
yes.
So you said should that time, earlier you were saying it was a commission directive. The last paragraph on page 9, do you mind to read that?
The commission confirms that any future EDR contracts entered into by Kentucky Power can be submitted via the commission's electronic tariff filing system, and that the commission will establish a formal proceeding if further investigation is needed to determine the reasonableness of any EDR contracts submitted through the electronic tariff filing system.
What part of that paragraph do you read now as being compulsory?
Well, I do see the word can, if that's what you're referring to.
Well, I was specifically, but earlier your testimony was that the commission directed Kentucky Power to file them through tariff filing. Would you agree that the order actually says that you all can or may file them through the tariff system?
I agree. I
Okay.
thought it said that we should or shall. I agree. I made a mistake.
So I just want to be clear, we did not require you all to file it through the tariff system.
That is correct.
Okay.
It said we can submit them, and we have.
All right, and then and this may just be, sort of a non-attorney in the weeds sort of, we'll see here in a second.
Okay.
You're responsible for Kentucky Power's tariffs, right? For filing the tariffs, reviewing the tariffs.
Yes.
Yeah, I get that probably the Kentucky Power president is the one that has their name at the bottom of the tariffs. Maybe you do.
I do.
Okay, you do.
Yeah.
So you're responsible for the tariff. That's even better. So, would you agree that when tariff filings are made and they go into effect, whatever it may be, that cover letters are not included in your all's tariffs? Let me ask you this way.
I don't know.
You know all of your tariff pages, right?
Uh,
You go to our website, you click on the link to tariffs,
Yeah.
and you can scroll through your tariffs page.
I can, yes.
Are you aware of any cover letters included in that?
No, I think that it's just the first page, if you call that a cover. It's not a cover letter, it's just the first page of the tariff.
Yeah. And then special contracts or contracts, you all have a number of those on file at the commission. Would you agree?
Yes.
Have you ever accessed those?
I have not, but my staff has, and they told me that the cover letters are there.
The cover letters are there. What do you mean there? When the filings are made or
when-
when the contract is either accepted or approved?
I thought it was when the filings were made. I'm not certain about the other part.
Okay. So, then finally, Mr. Bellamy, do you mind to bring up the EDR tariff one more time? We talked a lot about the first term of service. Do you mind to look at the second terms of service under tariff EDR?
Do you want me to read it?
Oh, just look at it for a second. I just want to make sure you're familiar with it.
Okay.
Okay. What does that mean to you?
Pretty much what it says. The new or increased load cannot accelerate the company's plans for additional generating capacity during the period for which the customer receives a demand discount.
Okay. What fact scenario would new or increased load accelerate the company's plans for additional generating capacity?
Well, I suppose, if one of those economic development, prospects that we have that are, a much larger load would materialize, I suppose that would drive that. In general, just increased load, a large increase to load.
Why does the materiality of the size of the load matter?
Because, it's different. 800 megawatts is a lot different than 2. For, 2 megawatts is still, a sizable load. That's still an IGS customer. But 800 is certainly a different magnitude.
Well, I get that it's bigger, but what does it have to do in terms of, what does it have to do? What does the magnitude have anything to do with whether it accelerates the need for additional generating capacity?
If that capacity is not available to be contracted for, then I would assume you'd have to construct it or buy it.
Well, but buying it, you'd still end up with sufficient generating capacity, right? That's what your testimony has been today. That buying capacity is the same as owning it,
Buying it or building it, yes.
even at 1 and 2 year increments, right?
Yes.
Does this contract accelerate the company's plans for additional generating capacity?
No, I don't believe it does.
Why not?
It has a firm of 1 megawatt. So it's like I said, it's kind of a rounding error in the total load that we have right now, which is around 1,000.
How about 100 megawatts?
We would have to do the analysis on that.
What would the analysis be?
I think the analysis would be similar to analyses done in the IRP, where it's modeling, it's taking lots of inputs, load forecasts, fundamentals prices, all those kind of things. I don't think I can sit here today and say, yes, 100 megawatts would do it. It would have to be studied, analyzed.
You were specifically talking about 800 megawatts was the one that would sort of be different than 2 megawatts. Would you agree tariff EDR is limited to 250 megawatts?
I would agree, and I just kind of pulled 800 out of the air.
Okay, so would you agree it's something on this side of 250 megawatts by definition, since it's in the tariff that's limited to 250 megawatts?
That's fair, yes. But an 800 megawatt load could be a special contract outside of EDR.
Right, but you're not arguing that tariff EDR applies to special contracts entered into outside of tariff EDR, are you?
No, no, I'm not.
Would you agree that if a customer doesn't, especially, do you think it's imperative or important, whatever word you want to, well, let me ask it this way. Do you believe you have a good appreciation for the variable cost? And by you, I mean the company. That the company has a good appreciation for the variable cost of serving this customer for the next 10 years?
Based on the information that we know now, I would say yes.
Okay. And you have some idea or certainty as to the capacity costs for the remainder of this delivery year and the next 2 years? Is that what you told Mr. Smar?
Yes.
Okay. For the subsequent 7 years, do you have an appreciation for what the capacity cost is?
I do not. I haven't seen any, forward information on that.
Okay. Do you have an appreciation for what the energy cost will be for the 10-year period of the contract?
I do not.
Does the company have an appreciation for what the energy cost over the next 10 years is going to be?
Someone might. I'm not aware if they forecast that stuff out that far.
If you owned generation that you anticipated being around for the next 5 to 10 years, let's say 10 years, would you have a good appreciation for what the forward cost curve of that particular generation might be?
Someone in our commercial operations group probably does, but I do not.
If you don't know what generation you're going to have for the next 10 years, does that make it harder? Just by definition?
I don't know that I can answer that. I'm sorry. I'm just not an expert in that area.
Well,
I would
Yeah, but I'm asking a
rather
pretty
not.
direct question that if you know what your generation is going to be, and you know what most of your cost inputs are, you have a good idea of what your cost output is, right?
Yes,
But you don't know what your generation is going to be for the next 10 years. Would you agree?
I do not. We're working on that.
You do not know or you do not agree?
I do not know at this point for certain what those resources are going to be. That's correct.
Okay. The use of those resources. Taking a big step back. You wanted to make sure I knew earlier how important these EDR opportunities are to the company's future. Is it a positive benefit for the company's future if the contracts ultimately do not cover their variable costs, never mind contribute to fixed costs?
I think that they need to cover the variable costs. They need to cover that and make contributions to fixed costs. I mean, they don't make sense otherwise, but they certainly need to pass that threshold.
On a rate making, and I'm not asking cost of service necessarily, but like big picture sort of, this is your bailiwick here. If the EDRs are approved or they go into effect by virtue of the law, the suspension date, they get accepted for filing, whatever the operative term.
Okay.
They're in effect.
Mm-hmm.
And ultimately, the variable costs change throughout the term of the contract. And the fixed amount or the amounts that the customers actually pay don't cover those variable costs. Under what scenarios are the company, under what scenario is the company at risk of that occurring? Like it's shareholder dollars that are not recovered? And at what point is the risk of that on customers' backs?
I'm not sure of the exact breakdown of that, but I guess what I would say is that you have to look at these contracts over the entire term, not just, this year versus that year. I mean, it's possible that, they're going to be underwater, so to speak, in the first year or two. That's when the heaviest discounts come, 50%, 40%. But that last part, the 6 through 10, if it's a 10-year contract, is at full tariff rates. So I think you have to look at it in total.
Okay. Would you agree that $1 in 10 years is not the same as $1 this year?
Yes, I would agree with that.
Would you agree then it's important to make sure that you're discounting those, assuming that the best year is in year 10, that it's important to discount that to year 1 so that there's an apples to apples comparison on a net present value basis?
I think that the way the company does it is most appropriate, and if Witness Khan may be able to provide further detail on that.
Insofar as capacity purchases cost more than you're recovering through the capacity purchases to serve customers, are costing more than the customers are paying for those capacity purchases. The net of that is recovered from other customers through tariff PPA. Would you agree?
Yes.
Okay. And you've looked at, the company has looked at that. Let me ask it from this perspective. How do you look at that when you guys are out here negotiating these discounted rates? I'll take something cheaper than I can get it today. So I don't blame counterparties for this, but where are you all looking and making sure that you're in a position to be offering these, because they will result in net benefits to other customers? How are you looking at these rate-making treatments for these costs in determining whether other customers are better off?
Well, in the case of the contract that we're talking about, they're tariffed rates. So there's really not a negotiation in that, like there would be in a special contract case, where you might look at, you have to do a calculation of what are the variable costs to serve, and then at whatever negotiated rates you're talking about, is that covering that variable cost and making a contribution to fixed costs.
Okay.
But in this case, they're tariff rates.
That's great. The tariff envisions a scenario in which the tariff rates aren't enough. Would you agree?
In what respect?
Well, don't want to belabor the point, but with respect to terms and condition number 1, that there's an incremental cost that exceeds the amount of rates being recovered from the customer, and therefore allows the utility on a dollar-for-dollar basis to cover that cost.
I understand that.
Okay. Just to be clear, because I didn't ask the question specifically, I don't think as directly as I would. Under what scenario, going back on this big run, where the commission said to the extent Kentucky Power is required to purchase capacity for Big Run, those costs would be borne by Big Run. Is it your testimony that there is no fact scenario in which Kentucky Power will be required to purchase capacity for Big Run?
My testimony is that we would have to purchase capacity for all of our customers, not specifically Big Run, but specifically all of our customers.
Without Big Run's demand, would you purchase less capacity than with Big Run's demand?
I believe we've talked about this, but if it's not included in the load forecast, then it would not be part of the purchase.
So is that a yes?
Yes.
Under what rate-making mechanism would you put into effect terms and condition number
1? I don't understand your question.
Yeah, let's just say that whatever scenario you believe would be implicated by terms and condition number one, the dollar for dollar reduction of demand discounts. How's that effectuated through like between you all figuring out that you had to buy and it cost X and that you need to reduce the discount by Y, and then you need to send a bill to that customer? I'm trying to make sure I have an appreciation. Is that a reduction through tariff PPA? Is it gonna be its own separate line item? I don't think I understand how that provision in the tariff would even apply in terms of billing a customer and actually reducing that demand discount.
Well, we've had numerous discussions about this, and we haven't come to a final answer as to how we would even do it.
Okay.
It would be very complicated to even do it.
And just to be clear, in terms of that dollar for dollar amount, that dollar for dollar term being referenced in the contract, is the contract in this Cyber Innovations case the same as the previous Cyber Innovations contract that Mr. Bellamy was referring to earlier, that the terms says that the company may reduce, I'm paraphrasing, but the company may reduce dollar for dollar the discounts insofar as it has to?
It's virtually identical.
Virtually
Yes.
identical. I think that was the verbatim from your testimony, right?
I think so, yes, sir.
Okay. And then finally, who does your all's, assume that you, how do I say this? I'm gonna say it correctly, Mr. West. Assuming you all have no EDRs for like a couple of years period, right? Do you all do a marginal cost analysis internally for like a hypothetical 1 megawatt load?
I know my team doesn't, but I can't speak for like any particular group in the Service Corps, AEP.
Yeah, and the reason I ask is, going back to the question I asked you earlier about, I used the word negotiating, but I appreciate that you're talking about tariff provision. But the tariff still has to make sure that the rates charged through the admin 327 is in effect, right? You may have a couple of exceptions technically through the tariff, but you're still required to file marginal cost analysis with an EDR filing to make sure that a contract covers its variable costs, correct?
Yes.
Okay. But I guess what I'm asking is the time in between bringing them to the commission. Are you all looking at what your variable cost is and making sure that a hypothetical 1 megawatt load actually covers its variable costs before going out to a customer and informing them and talking to them about tariff EDR? Or frankly, sorry, let me extend the question, or coming to the commission asking for some sort of relief because you don't think it any longer covers the variable cost?
I'm not 100% sure, but I think that we do have an appreciation for that before we talk to the customer. I can't point to anything specific, but that's running in my mind that we do have that, kind of information.
Let me ask you this way, Mr. West. If you don't think that the marginal cost of adding an additional load, 1 megawatt, 5 megawatt, whatever it is, hypothetical, whatever, if you don't believe that that new load will cover its variable or marginal cost and thus won't contribute to fixed expenses and basically would actually leach
Right.
off the rest of the system,
Right.
where do you, I guess, what would you do to effectuate a change with tariff EDR? Would you bring it to the president's attention? Would you file an amendment, a withdrawal, a suspension? I'm trying to have an appreciation for what's the trigger internally when you all, if you all would ever find out that your marginal cost isn't going to be covered, and therefore you shouldn't be offering these discounted rates.
Would we then talk about changing tariff EDR?
Yeah, not even just, what would you do, I guess is really the question. If you, in between offering these,
Yeah.
did your own internal marginal cost analysis and said, we don't think 1, 2, 5, 20 megawatt expansions under tariff EDR cover their marginal cost anymore. Like maybe as a result of getting this RFP back of what capacity is gonna cost, right? If you get this RFP back and, capacity costs $500 a megawatt day, that's the best offer you got, and you all run it through a hypothetical 1 megawatt, marginal cost analysis, and it's negative every time, what would you do in relation to tariff EDR?
I honestly can't answer that right now. I'm not sure, but I think that, we would probably, seek special contracts outside of tariff EDR. But we would still have to look at marginal cost. I mean, I think that that's imperative.
Yeah, and I just to be clear, I think maybe because I'm not great at asking questions very clearly, but I took earlier that your testimony was that a tariff, a contract, whatever it may be, where a customer is not covering all of the incremental, marginal, variable, whatever word you want to use, cost to serve them is bad for the remaining customers, right? If they're not contributing to fixed expenses and it's actually other customers are paying more to serve them, that's a detriment to all the other customers.
That is a temporary detriment. Like I said,
The
you
life of the contract.
gotta look at the life of the contract.
And I'm talking life of the contract. If over a life of a contract, they're not paying their entire full cost over the life of the contract, that is bad for the rest of the system.
That's a risk, yes.
Yeah.
That is a risk.
I appreciate it, Mr. West. Sorry to have to plow the same ground as last week, but that's a different case. So,
Understood.
Oh, I do have one last, on timing. That 2018 case that we were talking about earlier, that the order came out in 2019 on Big Run, assumed that the Rockport UPA was going to expire and not be renewed. Would you agree?
If that's what it said, I guess.
I mean, that was what that operative December 9, 2022 date that it was referencing was, right?
Yeah.
But I think there were a lot of assumptions in like the 2017 rate case and the 2020 rate case, given the pricing of the UPA, that Kentucky Power wouldn't extend it and allow it to expire. But that was actually sort of, the ball was in your all's court in 2022 as to what you all did upon the expiration of the Rockport UPA, right?
That's right.
Yeah, like technically you all could have negotiated a new one or entered into it longer, but the assumption was, the working assumption was, it was not, I take it from the company, it was not worthwhile to renew at the same terms. Would you agree?
Yes.
Yeah, because of the cost. Okay.
Yes.
All right, thank you, Mr. West. Ms. Glass, given the time, and I want you all to be efficient and I don't mean efficient as fast. I want to make sure.
We'll always be efficient.
Yeah, we always have our day in court here. Let's go ahead, given that I know you'll have two more witnesses and we have the joint interveners witnesses. Let's go ahead and take an hour break for lunch. And then we'll come back and I'll let you conduct your redirect. We'll take about an hour and 5 minutes, your redirect of Mr. West, and then see if we have any follow-up questions. So we will take a recess until 12 o'clock, and we'll come back then before we.
Until
1 o'clock, I know, I keep saying 12, I'm sorry. But until 1 o'clock. I do want to make sure, Ms. Glass, that you have all those documents that I referenced earlier, the tariff, which of course is, and the case record, and then that application in 2018. Do you have all those documents available to you?
Yes.
Okay.
Electronically, I do, yes.
Okay, would anybody like us to make copies of those to provide to anybody when we come back? We're happy to do it during the interim.
We'll take you up on your offer.
All right, we'll
Yes,
bring
please.
4 copies back for you.
Thank you.
Okay. All right, we'll be in recess until 1.
Mr. Chairman,
Actually, can we go back off the record for just 1 second? We're back on the record in case. What do you have on your monitors?
Just the time.
We're back on the record in case number 2022-00424. Mr. West, just remind you, you are still under oath. Do you have those documents, Ms. Glass? Do you-
I don't have paper copies, no.
Great. I think Mr. Bellamy is going to make sure that you have 4 paper copies, one for yourself and your 3 witnesses.
That'd be great, thank you very much.
Nobody else wanted one, so.
Did you need the EDR tariff page also?
Oh, no, we don't need that, thank you.
Just after the break, just for the record, Mr. Bain said that he needed to step out, but would be back in short order. And then just as a procedural matter, we're going to take our first break at 2 o'clock today. We'll just take a short 10, 15-minute break, and then we'll figure out what we need to do after that 2 o'clock break. So, Ms. Glass, would you like to ask any questions? And you redirect Mr. West?
Yes.
Please proceed.
Mr. West, earlier you were asked, I think basically whether you knew if Cyber Innovation would not continue to operate their Rock House facility if the EDR contract were not approved. Do you remember that?
I do.
Is it your understanding that Cyber Innovation expected this contract to be approved within 30 days, like its other facilities contract was approved?
Yes, that's correct. That was in my rebuttal testimony that the first one was approved in 30 days. So they began operation, fully anticipating that this contract would follow the same path.
And Cyber Innovation has indicated, both in its application for an EDR contract and otherwise, that it would not have located in the service territory absent the EDR discounts. Is that correct?
That's correct. That was also included in my rebuttal testimony as well.
Mr. West, can I have you open up the proposed special contract to section 4.9, please?
Yes.
So that provision, and you talked about this provision earlier, but it says the customer's been provided a copy of the the company's tariff EDR. Customer recognizes that during the term of this contract, that Kentucky Power may be required to acquire additional capacity on behalf of customer. In the event the company is required to acquire additional capacity on behalf of customer recognizes and agrees that customer's IBDD may be reduced in accordance with paragraph 1 of the terms and conditions of tariff EDR, tariff sheet 37-1. Is that your understanding of what the contract says and what tariff EDR says?
Yes, that's my understanding.
And so, as the company has said many times today and in the filing, the company maintains that it currently has to purchase capacity to serve all customers, correct?
Yes.
And the company does not assign specific capacity purchases to individual customers, correct?
That is correct.
And the company also does not assign incremental capacity purchases to individual existing customers who may be causing an increase in the capacity need, correct?
That is correct.
And is it also your understanding that the company is operating under the same construct now as the company was under the Rockport UPA? Meaning the company was purchasing capacity under the Rockport UPA, and it is also purchasing capacity now.
Yes, that is correct.
And is it for these reasons that the company believed that the credit reduction provision in tariff EDR didn't apply in this situation? Is that correct?
That's exactly right.
But the company asked for the commission to either confirm its interpretation or grant it a deviation, correct?
Yes, we did.
And so if the company's interpretation is not agreed with by the commission, then the commission could either grant the requested deviation or not grant the requested deviation, correct?
Correct.
So the inclusion of this provision in the contract that you just read and the use of the permissive word may in section 4.9 Is it your understanding that the company included that provision in the contract to provide for the instance that the commission did not agree with the company's interpretation or did not grant the requested deviation?
Yes, that's precisely why it's in there.
Earlier, you were also asked whether the company believed that it had sufficient capacity now for the entire 10-year term of this contract. Do you remember that?
I do remember that.
Would you agree that the company will always ensure that it has sufficient generating capacity to serve its customers, whether owned or contracted for?
Yes, we will always do that.
Your Honor, I just wanted to confirm with Anthony that monitors are not on. I just want to confirm we're on the record.
Yeah, we are.
Okay.
Earlier, there was some discussion about the company's practice of entering into bilateral contracts or other contracts for capacity, whether long-term or short-term. Do you remember that?
Yes,
Would you agree that the company enters into contracts for capacity based on what's prudent to do at the time and based on what the company knows at the time?
yes, that's true.
So would you also agree that it may be possible to enter into longer-term capacity contracts, but for various reasons that someone like the commercial operations team is an expert on, they chose instead to enter into shorter contracts?
Yes, that is the case.
But you and I aren't capacity procurement experts like, for example, the commercial operations team is, correct?
No, I am not.
Okay. And if there were any additional detail required or needed on the company's capacity procurement strategy, that information could be procured from the service court.
Yes,
Earlier, you were also asked why the, I'm going to call it the credit reduction provision in tariff EDR, where the company has the provision that we would reduce on a dollar-for-dollar basis EDR credits in the event that capacity purchases are have to be made on behalf of the customer. You recall that provision?
I do.
Okay. And I think you were asked why that provision was in tariff EDR. So first and foremost, would you agree that that provision allows Kentucky Power to offer EDR contracts in times when it has sufficient generating capacity and times when sufficient generating capacity is not available?
Yes. I would
And so
agree.
that essentially provides a deviation from the requirement in administrative order in Administrative Case 327 that allows EDR contracts only to be offered in times of excess capacity.
Correct.
And so also in that provision, in the company's tariff, the credit reduction provision, that also provides for what happens with EDR credits in the instance that the company does have to procure capacity on behalf of the customer, correct?
Correct.
And as we've just talked about, the company stated its interpretation of that provision or asked for a deviation in this case, correct?
Yes.
However, if the deviation is not granted, tariff EDR still allows the contract to be offered subject to the discount reduction provisions, correct?
That is right.
And if the commission affirmatively tells the company that it doesn't agree with the company's interpretation of its tariff or doesn't grant the deviation, then the company would implement the terms of the tariff, including the discount reduction provisions, correct?
Correct.
Mr. West, in your opinion, does this contract very plainly meet the requirements of tariff EDR and administrative, the order in administrative case number 327?
I believe it does.
And even if the commission does not grant Kentucky Power's requested deviation from the credit reduction provision in tariff EDR, would the contract still plainly meet the requirements of the company's tariff and administrative, and the order in administrative case number 327?
Yes, it would.
Would you agree that all the company is doing here is implementing the commission's order in administrative case number 327 and the terms of its tariff?
Yes, I would.
Earlier you were also asked essentially whether the company felt comfortable that Cyber Innovations would be here and operating in the company's service territory for the long term, and I believe your answer to that was yes. Do you recall?
Yes, I remember that.
Was your answer based on all of the representations made by Cyber Innovation to the company?
Yes, that's exactly right.
Based on those representations, you don't have any reason to believe that Cyber Innovation wouldn't stick around for the term of the contract?
That's correct.
So we've talked a little bit in this hearing about how the company is planning as part of its IRP to add new owned generation.
Yes,
So would you agree that any additional customers that the company could add would have the effect of spreading the costs of building or buying that new generation over more customers?
yes, it certainly would.
Would you also agree that the best way to attract new large load over which to spread those costs is through discounted rates?
It is a very powerful tool that the company needs in order to attract that business, yes.
Earlier, you testified more than once that the company ensures that it has sufficient capacity to meet its summer peak as required by PJM, correct?
Yes,
And otherwise, it can rely on PJM to meet its peak load in, excess of what that summer peak may be in the winter. But it doesn't have to contract for those, for that capacity up front under the PJM construct, is that correct?
that's right.
It just has to contract or own sufficient generation to meet the summer peak.
That is correct.
And so, by doing so, because Kentucky Power is a winter peaking utility, if it contracted or had sufficient capacity or built or owned sufficient generating capacity to meet the winter peak, it would require more generally, correct?
Yes,
And that would come at a higher cost, correct?
absolutely.
And so, contracting for capacity sufficient to meet its winter peak, when it's not necessary to, and the company has the capacity available to it through PJM, doing so would unnecessarily cost customers more, correct?
Absolutely.
Are you aware of whether the company has ever had a supply-related outage under this construct after it joined PJM?
I am not aware that it ever did.
Earlier, you were asked whether the company provided a marginal cost study that included generation capacity costs. Do you recall that?
I do recall, yes.
Is it your understanding that the company provided as errata attachment 3 to your testimony a marginal cost study that includes generation capacity costs?
Yes, I'm aware.
And could Witness Khan answer questions with respect to that marginal cost study?
She could.
Earlier, you were also asked whether an accurate marginal cost study is imperative to ensure other customers benefit from the EDR contract. Do you generally remember that?
Yes,
Is it your understanding that there are multiple reasonable ways to perform a marginal cost study?
yes, there are.
And is it your understanding that the marginal cost study has to be made on information known at the time, correct?
That is correct.
Is it also true that the marginal cost study is not used to actually predict the future of what will occur?
That's right, it's not.
And as you said, Witness Khan is probably the best witness to answer any additional, more detailed questions about the marginal cost study we filed here.
Yes.
So I'd like to go back to section 4.9 of the contract and section 1 of the terms and conditions of tariff EDR that I've characterized as the discount reduction provision. Earlier, the chairman asked when that provision would ever apply, based on the company's interpretation that it's provided here today. Do you recall that?
Yes.
And have you had a chance to confer at a high level with the AEP Service Corps, who have a better understanding of when this provision would apply?
I did, very briefly over lunch.
And so, the company still maintains that it is currently having to purchase capacity for all customers, which includes existing EDR customers.
Correct.
And the company's position is that the discount reduction provision in tariff EDR doesn't apply when we're having to procure capacity to serve all customers.
That is correct.
But is it your understanding that it would apply when we have to make a true incremental capacity purchase to serve a particular new EDR customer?
That's true.
And so, is your understanding that once a customer shows up in the company's load forecast and the company is able to identify whether the customer's load is driving the need for a true incremental capacity purchase, then we'd be able to identify the amount the company needed to procure to serve that customer, and the company would then assign that portion to the EDR customer and reduce the EDR credits commensurately?
That's right, to the extent that we could, pin down to that one customer that was what the driver was.
And when I say a true incremental capacity purchase, is it your understanding that that means essentially capacity the company otherwise wouldn't have purchased,
Correct.
absent the customer's need?
Right.
Do you have an understanding of when the Cyber Innovation Rock House load would show up in Kentucky Power's PJM load forecast?
Yeah, in general, it shows up in the load forecast the year after that they would start operations.
Is it your understanding that it's very likely that this 1 megawatt of firm capacity would be accounted for, or there would be excess to cover the 1 megawatt in what the company ends up purchasing to serve all customers?
Yes, it would. As I said this morning, it's a rounding error.
Meaning the load is so small in comparison to the company's total load, it's very unlikely that it wouldn't fit in that delta between what the company would purchase to serve all customers.
That's exactly right.
I believe those are the only questions that I had.
Mr. Ward, do you have any more questions?
No further questions.
Mr. Bellamy?
No, I don't think I do.
Yes, sir. Mr. West, you're familiar with the company's current integrated resource plan?
Yes, in general, yes.
You helped formulate it, at least from a regulatory perspective?
Yes, I worked with the team.
In formulating that, did you look at the record of the previous integrated resource plan?
I did. I mostly just reviewed the executive summary and the 3-year action plan.
Gotcha. Did you review the order, the substantive order that the commission entered in that case?
Yes, and the staff's comments.
Okay. Could you bring that, could you bring the NUNC order up first? Just forward.
quick check with Anthony. For some reason, the screen's not, I have it shared.
Okay, there we go. All right, so this is a NUNC order in that 2019 443 case, Mr. West.
I'm sorry, sir, it's a what order?
Yeah, I'm about to explain it. We call it a NUNC order. Do you see down there in italics, about 5 sentences down, NUNC pro tunc?
I see.
I
Yes.
don't know the Latin phrases, but I think it's basically this for that. It's a replacement, like a like kind of replacement. You may have seen them, the commission
Yeah, yeah.
enter them in other orders, but it's
Yep.
things that courts and administrative agencies can do where it's just a small mistake and we're removing something and replacing it. We call them NUNC orders informally around here.
Okay.
But this is one of these NUNC orders that were entered a few days after the order I'm about to show you. Do you see, if we could scroll down, that the commission replaced the second sentence in the first paragraph on page 4 and the third sentence in the first paragraph of the discussion section on page 4? So just read that first sentence just for a second.
Under number 1 there?
Yeah, sorry. First, comma, Kentucky Power participates in PJM as a fixed resource requirement, parenthetical FRR entity.
Yes.
Okay, and then the second one, the replacement language is that FRR entities are expected to maintain adequate capacity to serve native load, plus a reserve margin as required by PJM, and any surplus can be sold in PJM's capacity market. Do you see that?
I do.
So I just want to call particular attention to the word entity in both of those sentences, or entities. So there's the first one after FRR, the first one, and then the second one after FRR is entities. Do you see that?
I do.
Okay, so if we can go to the final order. I said the final order, the closing order in that case, that was entered, I think, June 4th of 2021. And we can go to page 4. So we're just gonna go to the discussion section of the order, if you don't mind. So the discussion starts off, tell me if you disagree with what I'm reading here. This is what it says. Regarding the Attorney General KIUC's contentions concerning issues raised in the staff report, the Attorney General KIUC appear to misunderstand Kentucky Power's participation in PJM. I promise I'm not reading this to try to embarrass Mr. Warner, Mr. Boehm. I'm just, this is an important provision here. Okay. First, Kentucky Power participates in PJM as a fixed resource requirement. Do you see that? So that's the sentence I got changed. You notice the entity is what got added after FRR, right?
I see that.
Okay,
yes.
so it should say, first, Kentucky Power participates in PJM as a fixed resource requirement, or FRR entity. Then it goes on to say, FRR, insert, entities, are expected to maintain adequate capacity to serve native load, plus a reserve margin as required by PJM, and any surplus can be sold in PJM's energy market.
Yes.
So with that NUNC pro tunc language, that makes sense. And that's how you understand the FRR construct to work?
Yes.
Okay.
Yeah.
In contrast, the order goes on, EKPC participates in PJM under the reliability pricing, RPM construct. Here, EKPC offers all of its capacity into the base residual auctions and purchases back the amount PJM indicates is required. The value, as it relates to capacity, between the two memberships is significant. Although and then we'll scroll to the next page. Although the Attorney General KIUC are correct that both East Kentucky Power and Kentucky Power are winter peaking, that fact alone does not drive benefits for both. As a winter peaking utility that participates in a summer peaking RTO auction, the value of EKPC's PJM membership as it relates to capacity is that EKPC has enough capacity to meet its winter demand, but that means EKPC is long during the summer. Since PJM planning is conducted using summer peaks, EKPC is able to monetize being long on generation in the summer by selling more capacity into the BRA than it must purchase. Contrary to the Attorney General KIUC's suggestion, the value of EKPC's membership in PJM's BRA is not that EKPC will or is maintaining less capacity than necessary to serve its native load. Nevertheless, the self-supply construct that FRR seeks to satisfy is intended to allow utilities who have sufficient generation to choose to not participate in the BRA. So up to now, have I read this correctly?
Yes.
Okay. So it continues, if you could scroll, Mr. Bellamy. The order goes on to say, advocating to explicitly not have enough generation to satisfy retail demand and using the remaining PJM members as a backstop is contrary to the FRR construct and Kentucky Power's obligation to serve of service under Kentucky law. What are you, when you're talking about not having enough generation to meet winter demand, your native winter demand, and instead only having enough summer capacity to meet your PJM requirements, what portion of that is consistent with the commission's finding in this June 4, 2021 order?
Clearly, Mr. Chairman, we have a difference of opinion. And the company's position is that the PJM construct that we participated in, regardless of what this says, has benefited customers tremendously over the past few decades. I don't think we can dismiss that fact.
Okay, that's a fine position for you to take, but how is your position on the company's interaction with the PJM FRR plan consistent with the commission's order?
Mr. Chairman, I would refer that to the show cause filing that we made last Friday. I believe it answers that question.
Okay, I can't refer to the show cause order. When we're making our decision in this case, we're limited to this record. That's Kentucky Power's position, right? I'm not asking for a legal opinion, but you're aware that you would like us to make our decision based on the record of this case, are you not?
I'm aware of that, and we'll
Okay.
file it in the record.
Okay, so is what the commission was explaining Kentucky Power should do in relation to its FRR what you are doing?
The company does not agree that using the remaining PJM members as a backstop is contrary to the FRR construct. We just do not agree with that.
That's perfectly fine that you disagree with that, but that wasn't the
Yes.
question. The question is the company doing what the order expected them to? What the order said they should be doing?
The company is doing what is best for its customers. That's what we're always going to do, is what's best for our customers.
Okay. Is what you're doing consistent with what is in this order?
I don't believe it is, but we're doing what is best for our customers, as we always do.
So this was entered 2 years ago, right? June of 2021.
If that's the date on it, yes.
Well, so, I don't know, this is just a little inside baseball here.
I can't see the date.
The date always goes in year, first four, do you see after the case number 2019-443 in the URL and the address?
Yes.
Okay, so you see, so it'll be
Date,
our
yeah.
website, filings, 2019, 2020 cases, then 2019-443, then hash, then 2021, that's the year, 06, that's the month, June 04, that's the date that it was entered. So June 4, 2021 would be more than 2 years ago, correct?
Yes.
And then we always stamp it, well, we now stamp it, which you can see.
Yeah. Yeah.
Okay,
Yeah.
so this
a
is
lot-
2 years ago, and you filed an IRP since then, correct?
Yes.
Is the IRP consistent with the commission's order from 2 years ago?
We're still operating the same way we were 2 years ago.
Okay.
A lot has happened in the last 2 years, as this commission is well aware. Not the least of which was the failed sale to Liberty.
Okay. So your answer a second ago to Ms. Glass, how do you pin down the demand of one customer?
That's why I said to the extent that you could.
Okay, so I
Not
guess,
sure you can.
so of what benefit is this response that you got secondhand from AEPSC if in practical effect you don't actually think you're able to pin down the demand from a single customer?
Again, Mr. Chairman, I'm not the expert on metering, I'm not the expert on a lot of things. But to the extent that you can determine it, then we should enforce the tariff as it's written.
Okay.
That's my stance.
Okay. So the reason you haven't been with Big Run, is that because you don't think you can identify the 3.6 megawatts?
No,
Quote, pin
it's,
down the one customer?
it's because at the time that Big Run was approved, we had the Rockport UPA. Their load was included in the load forecast. We were not purchasing 3.6 or whatever it was to serve Big Run alone.
Where did the order say alone?
I don't know, it's just a word I just used. I don't know.
The reason I ask is because your explanation earlier I took from his class on when the dollar for dollar would apply seemed to me as being a single instance that it would ever apply, which is you have excess, you give somebody an EDR, and that single customer pushes you over from having excess power to not having sufficient generation. Am I wrong that that's the single instance you explained?
During redirect,
That's right.
yes, that was my understanding based on that very brief conversation with someone.
And that would only happen, I understand from your explanation, the first year, right?
After that, they would be included in the load forecast.
Okay, so if a single EDR takes you from being excess to insufficient, you would charge them whatever you're short that first year, whatever you had to buy to serve them the first year that they put you into insufficient. And then every year after that, they still get a discount and don't have to pay dollar for dollar for the incremental cost capacity. Is that your testimony?
Once they're included in the load forecast, they're accounted for.
Okay. I just want to confirm, that's the scenario you're explaining that tariff provision applies to in your,
Yeah,
in your understanding.
in my understanding, and if you feel the need to give us a post-hearing data request, we'll do a better job of answering that, but that's the best of my understanding today.
And then if I have questions about tariff PPA, I just want to make sure I'm clear that I can ask those questions to Ms. Khan?
Yes.
Okay. And then just to be clear, because I don't want you to run off and then not be able to call you back, but I guess I can if I need to. I do have questions about the annual tariff PPA filings. I know Ms. Khan actually makes the filing.
Yes.
Is that something that's done under your supervision, or somebody that it's best if I wanted to ask specific questions about the filing to ask Ms. Khan?
Ms. Khan.
Okay, that'd be
Yeah.
great. Thank you, Mr. West. I appreciate it. Council, any redirect?
I don't, but we would like to request the opportunity to supplement the record with additional information on that issue, whether it's in response to a commission staff post-hearing data request or in some form of supplemental testimony like that.
We'll discuss that at the end of the hearing. How about that?
Okay, sure.
Before Mr. West steps down, just because it's pursuant to his testimony, similar to the hearing we had last week, does the company anticipate filing an addendum to the contract for the commission's consideration on the surety?
Yes, again, I think that I said that was in talks. It wasn't in writing at this point. Got to talk with our customer, but they have committed to do that should the contract be approved, yes.
Yeah, but see that therein
We
lies,
will-
therein
I
lies the
understand.
circular issue of the situation. And
I
that's why I asked
understand.
about pursuant to kind of the what came up at the hearing last week with Yvonne.
Yes.
I didn't know if you all intended on supplementing, again, we have a statutory date, this is a tariff filing.
Right.
If you all intended on adding an addendum or a change to the contract for our consideration in this case.
I don't intend to testify for Mr. West, but I think our understanding is we will confer with Cyber Innovation. We haven't had the chance to do that yet, and we will ask them to enter into an addendum. And if they are agreeable, we will do it and file it. We anticipate that they will be. but not having the chance to confirm that.
Well, and that's fine,
Yes.
the reason I ask is an issue of timing and testimony, is that
Right.
we have this in front of us.
Right,
We have what the record we have. We have to rule on the tariff within a certain amount of time, and
Sure.
tariff, contract within a certain amount of time, it is a tariff. And so I just throw that out there for your all's consideration, that sort of time is of the essence in terms of an amended contract for our considerations.
We will do
Understood,
that in a
sir.
timely manner and let the commission know either way, whether we intend to submit something. I think we can do that next week.
yes, we can.
No redirect, Ms. Glass?
No.
Okay. All right, thank you, Mr. West. Let's just go ahead and take a short break, get everything together. You have, would you like a paper copy of the order from 2019-443?
I don't think I need one. No, thank you.
Would anybody like a paper copy? Everybody's fine of the two, the NUNC order and the regular one? All right, so we will take a short recess. Let's go to back on the record in case number 2022-00424, excuse me. Ms. Glass, would you like to call your next witness?
Yes, the company calls Amanda Clark.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat and state your name and address for the record.
Thank you. My name is Amanda Clark. I am an External Affairs Manager for Kentucky Power. My address is 1645 Winchester Avenue, Ashland, Kentucky.
Ms. Glass?
Thank you. Ms. Clark, did you cause to be filed into the record of this case rebuttal testimony and responses to data requests?
I did.
Do you have any corrections or modifications to that testimony or to those responses?
No.
If I were to ask you those same questions today, would your answers be the same?
Yes.
Thank you. The witness is available for cross-examination.
Mr. Warren?
Good afternoon, Ms. Clark.
Hello.
In your rebuttal testimony, you stated that Cyber Innovation had not applied for the Supplemental Billing Demand Discount, or SBDD. Is that correct?
Yes, sir.
Okay. And is that because they're not creating enough minimal jobs to qualify?
It's been conveyed to us that they would add 2 to 3 additional jobs, and that doesn't meet the requirement of the tariff.
Okay. Do you know what the minimum number of jobs is required?
5.
When you're considering an entity for an EDR tariff or a special contract, are they all judged the same way?
Yes, sir.
Is there not a difference in the value one entity may bring over another entity to Kentucky Power?
No, sir. We do not discriminate based on the kind of business.
Okay. So while all economic development projects are important, but some are better than others, wouldn't you agree?
I would agree.
Would you agree that some economic development projects are more likely to succeed than others?
I would say that is a fair statement.
What does Kentucky Power look for in a potential economic development entity to ensure that they're going to be successful?
In terms of the tariff EDR, we look for 500 kW in load and 5 jobs to apply for the discounts. Really, we are not in the business of sort of picking winners and losers in terms of whether we believe that company can succeed. We're not involved in the day-to-day operations of that business. We have to trust that the information they're giving us is true and accurate, and base our opinions that way. But again, we can't say to a customer, "You're not good enough,"
Okay.
if they meet the requirements of the tariff.
Well, does Kentucky Power weigh the potential success of an economic development project seeking the EDR tariff or special contract against any detriment it might cause to current ratepayers?
And to some degree, I think we weigh, obviously, the cost to serve and whether or not that's going to affect our other customers.
Can you tell me how many special contracts or EDR tariffs has Kentucky Power done for an entity that has not qualified for the SBDD?
I'm not aware. I haven't been involved in all of them, so I don't know.
Do you know how many employees work at the Lone Fork facility for cyber?
Cyber's other facility, I believe they have 10 employed there.
And is Lone Fork under an EDR special
Yes, sir.
contract? Okay. Thank you, Ms. Clark. That's all the questions I have,
Thank you.
Chairman.
Mr. Bang?
Nothing, Your Honor.
Mr. Smart, Mr. Gary?
Yes, Your Honor, thank you. Good afternoon, Ms. Clark.
Hello.
Just a moment ago, in response to one of Mr. Horn's questions, I believe you stated that it has been conveyed to us that Cyber Innovations Group would plan to create 2 to 3 additional jobs at the Rock House facility. Did I hear that right?
Yes, sir.
How was it conveyed to you?
Through numerous conversations, and I believe that that's in their EDR application as well.
I believe the EDR application states they would be creating five additional
yeah.
jobs, is that right? So
That's
now
correct.
it's down to 2 to 3?
Yes, this process has been a very lengthy process in terms of how things started and where we are today. And so I think that probably accounts for the discrepancy.
Has Cyber Innovations Group provided any guarantee that these 2 to 3 jobs will be new jobs and not jobs that are shared with the Long Fork facility?
What they have said to us is that they would be new jobs at this facility.
Has Kentucky Power taken any steps to verify Cyber Innovation Group's jobs claims?
We have not. I'm not sure what steps we would take to verify that.
I believe you said in a discovery response to Joint Interveners 2-5 that the company relies on information from customers as to the number of jobs they'll be creating. Is that right?
Yes, sir.
So you take their statements at face value and you don't do anything further to verify them?
Correct.
Has Cyber Innovations Group provided any guarantee that these will be full-time jobs based at the Rock House facility?
They have told us that, yes.
The Rock House facility is already operating, correct?
Yes.
So have those 2 to 3 jobs already been created by virtue of the fact that the facility is currently operating?
I don't know the answer to that.
In your testimony, you discuss legislation passed by the Kentucky legislature concerning cryptocurrency. Is that right? Could you turn to page 6 of your rebuttal testimony?
Certainly. Okay.
And I'd refer you to the language on lines 4 to 5 regarding SB 255. Did you see that?
Yes.
It states that SB 255 added definitions to Kentucky statute to create tax incentives for the industry. Is that right?
Yes.
Have you reviewed SB 255?
When it was being passed, yes.
Did you review it in connection with authoring this testimony?
Yes.
Are you aware that SB 255 states that one of its purposes is to increase the usage of electricity in areas which have an abundant supply of electricity?
Yes.
So did you consider the terms abundant supply when authoring this testimony?
To the extent that the incentives that are offered in both of those bills signed into law increase the cryptocurrency activity in our service territory, yes.
Do you believe that Kentucky Power Territory has an abundant supply of electricity?
We have an abundant supply of electric assets that are particularly favorable to the cryptocurrency industry.
And so it's your view that as we've been discussing, and I understand there's a dispute in this case concerning whether Kentucky Power has sufficient capacity within the meaning of the EDR tariff, correct?
Correct.
Is it also Kentucky Power's position that it has an abundant supply of electricity pursuant to SB 255, or consistent with the meaning of SB 255?
I'm not sure I understand the relation to the language in the bill and how it determines whether or not we would accept this customer per this tariff.
We have no further questions, Your Honor. Thank you, Ms. Clark.
Thank you.
Commissioner Bellamy?
Were you involved in discussions with Cyber Innovations prior to the special contract being filed with the commission?
Yes, sir.
Can you just kind of provide a timeline of events, kind of starting with the first conversations with Cyber Innovations regarding this particular facility, going forward up until, the tariff was filed with the commission or the
Certainly.
contract?
This is another one of those conversations that began very, very early on in the wave of our crypto wave. So in summer of 2021, the owner of Cyber Innovations reached out to us to identify sites that might be suitable for crypto projects, and this was one of the sites that we identified. Through that process, of course, I guess I haven't mentioned in this record, I'm going to confuse my testimony from last week to this, I apologize. Through that process, I am merely the facilitator of connecting them with regulatory and customer service and transmission and all of the components of the company that they need in order to make their project go. So, like I said, in summer of 2021, we began sort of telling them where there were sites that might be able to service them. And through that process, they identified the Long Branch facility and then this one as well. Because those two facilities are pretty close to each other, I think they're about 5 miles apart, 5.5 miles apart. Essentially what they would do at Long Fork would affect the capacity at Brock House, sorry. And so we had to sort of keep an eye on exactly how we would serve both projects, and it just sort of evolved out of that. And that conversation, like I said, has been going on since summer of '21.
So the conversation was first started in summer 2021, and it was, at that point, it was sort of generic. There wasn't really the Rock House or the Long Branch facility. And you said that when you initially discussed it with them, there was discussion of sites that might be favorable. How do you identify a favorable site? What makes a site favorable over unfavorable?
Depending on what kind of business it is, there are attributes of a site that are necessary for them to operate their business efficiently. In the terms of cryptocurrency, they typically look for sites that are located near a substation, out of the way of other businesses, or they sometimes make noise, and so they want to make sure that that doesn't affect anything else. And so, and there has to be the capacity to serve them at that site. And we identified sites that had capacity to serve and met their requirements, and those two were two of the sites that popped up.
When you say capacity to serve, are you referring to generation capacity, or are you referring to capacity on the distribution circuit?
Capacity on the distribution.
And our Cyber Innovations, you mentioned that them being only 5 miles apart, that one site might affect the other. Are they on the same distribution circuit?
I'm not an expert on the way all of that works, but we have a team of people who look at how one load affects another load on the system, and those two sites were identified as affecting each other.
When was the prospect of an EDR rate brought up?
I believe our customer accounts managers were talking with the owners of Cyber Innovations for their Long Branch facility, and let them know that they qualified under the tariff for that, for those discounts. And they filed that, it was approved, and then they started moving forward with this one.
So did the customer service representatives bring it up after that facility was built?
No. When we started getting all of the crypto inquiries, we put together basically here's what we offer for businesses sheet that we usually circulated, and that the EDR was on there.
Okay, so you have sort of like, I guess, some promotional material.
We have an economic development fact sheet that says what we can do in terms of economic development, as well as the attributes of our region in terms of our workforce and all of those sorts of things, that when we're talking to a prospect, no matter what business they're in, we hand that out.
So when you're approaching any kind of business, you know, to determine whether or not they might want to locate in Kentucky Power service territory, you would kind of provide them that promotional material, which would include the EDR.
It has the EDR. It also has interruptible tariff on it as well as a possible discount for their load. Those are really the big tools that we have in order to attract.
Does it include just the tariff rates and things like that as
No,
other
we don't
tools?
usually get into tariff rates until we know load factors and where they're going to be, and are they going to take transmission service, are they taking distribution service, so we can't just put out a blanket, this is what your price is going to be for your rate.
Did Cyber Innovation ever indicate to you that without the EDR that they would not be willing to locate in Kentucky Power service territory?
They have indicated to our team that that was an important factor in locating in the service territory, that they would be somewhere else that would offer them a lower rate.
What was the context of that conversation?
Just a general, we need, everybody, I always say 3 cents because that seemed to be the standard. All the cryptos wanted 3 cent power. And of course, we would say we can't get to 3 cent power. So, but here's what we can do. And so it sort of evolved out of those kinds of conversations.
So it's 3 cents per kilowatt, is that what
Yeah.
they're? When did both facilities, the Rock House facility has been open since June of 2022, is that correct?
I believe so.
Are they fully built out such that, they have the equipment in place that their peak load would be 7 megawatts?
I don't know. I don't know the answer to that.
The other facility, when was that, when did it begin operations, I guess?
Long Branch began several months before Rock House, but I don't know the exact date because I'm not their account manager. I'm not versed on exactly when they went online.
So earlier in 2022? Mm-hmm. Are you aware, and this might not be something that's in your purview, but are you aware of the extent to which they've been requested at either facility to interrupt their load?
I'm not aware.
When you're, going out and trying to attract new customers, how do you define new customer typically? Would a new customer be someone who has a large facility in the area and they're going to bring another facility in, or would it just be someone who's new to the service area territory?
In that context, I think it could be either, because an expansion is also considered new load if it's not load that we've already had. But also, like I said, we recruit all different kinds of businesses in every sector, depending on RFIs that come from the state, from recruitment trips that we take with our regional economic development organizations that are, maybe targeted toward specific sectors. We sort of run the gamut.
I was looking at Kentucky Power's response to commission staff's first request for information, item 2, which it shows that you were the witness that responded to this.
Is it KPSC 1-2?
Yes.
Yes.
So, on 2B there, it asked about a description of any construction activity that Kentucky Power must undertake to serve the Cyber Innovations load. And the response there says there are still long-term projects the company plans to undertake in order to help support Cyber Innovations loads on the 69 kilovolt line. For example, the company will add a phase over phase switch and replace the metering equipment at Long Fork. Mm-hmm. could you kind of describe, that says for instant, or for example, and it mentions some other long-term projects. What are the other long-term projects that are referred to?
We actually addressed that in the KPSC 2.2 response. Phase over, phase switch, and metering equipment at Long Fork are still being addressed by the company to determine the most efficient and least cost approach. Furthermore, these items would be needed absent either Cyber Innovations Long Fork or Rock House load to address reliability on the circuit. So it was a reliability issue that we'd been looking at for a while anyway.
Okay, well, I was gonna ask about that on 2.2 also. I guess my question is, because on 1.2, you know, the response is there are still long-term projects the company plans to undertake in order to help support Cyber Innovations load on the 69 kilovolt line. And then it refers specifically to the phase over phase switch. How would that phase over phase switch help support Cyber Innovations load?
I don't know the answer to that question.
Okay.
This response was prepared with the help of our engineers.
I thought that might be the case. I was just, so I guess, would you have any personal knowledge of whether or not these improvements would actually be necessary on that circuit absent Cyber Innovations load?
According to the engineers, yes, that was a plan on that circuit. Because there is the new load on the circuit, then it sort of pushes those plans as well, because there are new customers on the circuit.
You say the engineer said that was the plan before?
To my understanding, there was the plan to do the metering and the phase over phase switches, and then the customers that were in those facilities or at those locations were gone. And so then it didn't make any sense to change out those things to upgrade that circuit. And now that there are customers in those abandoned facilities, now it does.
Okay, so if there were customers in those facilities, then they would have needed to do those improvements. There were no customers in those facilities until Cyber Innovations came, and because Cyber Innovations is now there, it is necessary to make those improvements.
For all the customers on that circuit, yes.
But absent Cyber Innovations locating on that circuit, it would not have been necessary?
That seems to be the logic.
Would you all be able to provide the costs of those upgrades?
I'm sure we
As
could.
opposed to in data requests? Okay, thank you.
Yes.
I don't have any other questions, thank you.
Thank you.
Good afternoon.
Hello.
You said that the EDR tariff is provided as part of the information that is given out to potential economic development opportunity companies.
Yeah, we don't provide the tariff. It's just a promotional piece that says these discounts are available, and then should they move any further, then we would provide them with the tariff.
So what sort of information do you provide about the discounts?
The demand discount is on there. And of course, we also mentioned that we offer a discounted rate for an interruptible load. It's just a bulleted.
Without details? Just
Without
that-
details, yeah.
That there could be a discount? So you don't talk about whether or not we'd need an exception or a deviation or
Right.
anything, just that there's potential rates?
These are possible.
Okay. Do you know if when you're marketing these things or in your discussions with these companies, if you ever talk about the dollar for dollar pass-through, or is that?
In the initial conversations, likely not. If we get into them specifically referencing the EDR or qualifying for the EDR, we do have those conversations. Like I
And would
said,
you-
we do provide the tariff and go through the tariff with them.
Would you be part of those discussions, or would someone else? do that?
Sometimes, a lot of times that falls to our customer account managers.
Okay, that's all the questions I have.
No.
Do you know when this customer took service initially?
I do not.
Can you screen on the confidential record, please?
Yes.
Just let me know when we're on. in the filing out into, it's the filing that was made the tariff filing. And so I'm looking at the contract. Ms. Glass, do you have a copy of the contract you could provide Ms. Clark?
I do.
I have it.
You have a
It's in
copy?
here, yeah.
She has a copy.
Oh, okay, great. There's that contract is as attachment 1. Do you mind to turn to page 16 of 24 of that contract?
Yes,
Okay. Do you see that there are dates of when the contract was filed?
yes.
Okay. And given that it may be confidential, you'll remember when the month that we just discussed, when they started operating. Okay. Earlier, you were talking about how they went ahead and started operating because of the length of time it was taking to do this. And I assumed by this you meant this case. I guess I'm missing how the time it's taken this commission to do this investigation has anything to do with the time that passed between when they started using electricity and the time that they signed the EDR. So can you give me a little explanation as to what it is about this investigation that is what caused them to start operating before the EDR went into effect?
It is my understanding that they are not going to ramp up to their full load without the EDR. So they're not running at their ask for the full load.
Okay. So, but the EDR is for the entirety of the demand, not the incremental that they've been using since when they started operating. You would agree?
I agree.
You said in your testimony or a second ago on the stand, that you don't, once they're in operations, you've got to have your eyes on the horizon, right? You got to be looking for the next economic development opportunity.
Yes, sir.
Specific to this location and this customer, did your discussions with them of an EDR for this account precede them taking service last year?
I did not have discussions with this customer about an EDR. That was their customer account manager.
Do you get a customer account manager before you take service?
They were a customer at Long Branch before they were a customer at Rock House, so they already had an established account. They were a customer.
Okay. Who at Kentucky Power or AEPSC can provide us an appreciation for why there is a time period, however long, between when they started taking effectively full service and signing this contract?
We can provide that, I'm sure.
Do you know who the person
It would be
is?
Sean Sumner.
Are you aware of anything in the record that would indicate why they started taking service when they did and the contract wasn't signed until it was signed?
I'm not.
Is that ordinary?
I don't know.
Okay. Ms. Glass, do you have any redirect, Ms. Clark?
Yes, I do.
Please proceed.
I'd like to provide Ms. Clark with a copy of our tariff EDR. I apologize, I don't have additional copies, but I'll represent that it's the tariff that's on Kentucky Power's.
That'd be fine.
So, Ms. Clark, earlier you testified that the minimum number of jobs for eligibility for the supplemental billing demand discount was 5 jobs. Do you remember that?
Yes.
Could you please turn to sheet 37-4 of that tariff? And under determination of supplemental billing demand discount, do you see that heading?
I would if I turned to the right page. Yes, I do.
Okay, I'll just read what that says. At the company's discretion, an SBDD, which is applicable to the monthly incremental billing demand charge, is available to customers meeting all availability of service and terms and conditions above, and that create at least 25 new permanent job opportunities in the facility, and that maintain those job opportunities in each discount year. Do you agree that that's what that says?
Yes.
So do you think that earlier when you testified that the minimum number of jobs for the SBDD was 5, that was incorrect?
I'm incorrect. Clearly.
So you would agree that the minimum number of jobs required is 25?
Yes.
Thank you. Ms. Clark, can you give me an idea or an explanation of what would you say are the main objectives for you as part of your job with Kentucky Power?
My largest objective in terms of economic development with my job at Kentucky Power is to recruit new business and new load to the service territory. And in that, also hopefully increasing the population and customers in Kentucky Power service territory.
So if I boiled that down, would it be fair to say that your sole job is to bring people and jobs to the service territory?
Yes.
And bringing people and jobs, that is what is meant by economic development, correct?
Correct.
And there are other benefits that economic development could include, right?
Correct.
Not just people and jobs, right?
Not just people and jobs.
Would you agree that discounted rates are the only real tool that you have to bring these types of customers that can bring economic development to the service territory?
That's correct. Absent being able to offer a discounted rate, we would be very much less competitive.
And so the company's tariff EDR currently allows the company to offer discounted rates to customers, correct?
Correct.
Would you say, based on your job for Kentucky Power and your expertise that you've gained in that job and elsewhere, would you say that economic development is more important to Kentucky Power service territory than other utility companies in Kentucky?
I would, because of the amount of load and the amount of people that we have lost with the decline of the coal industry and the steel industry in our service territory, bringing load, bringing jobs, and bringing people is really the only way that we're going to sort of dig ourselves out of this hole in eastern Kentucky.
Can you explain or provide some context around the constraints that Kentucky Power service territory has as far as attracting industries to locate here?
I can, and I've mentioned this, I think, in my testimony, but we are in eastern Kentucky relatively new to the economic development game in the sense that we haven't had dedicated organizations for the purposes of economic development like other regions of the state has for a number of years. One East Kentucky, I think, started in 2015, so we haven't been in it for as long as we should have been. One of the biggest obstacles that we had, because we have not been in this game as long as others, is the availability of good quality sites for industrial and manufacturing purposes. And what we have done in the last several years is identify those sites and get those sites ready should the opportunity arise. We are limited to industrial parks that are built on reclaimed strip mines. So there's a whole other set of obstacles in those. Those take quite a lot more site development than just a standard piece of land. We are constrained by, there is not a lot of flat land that is not in a floodplain in eastern Kentucky. We're also constrained in some regard because of location more than anything. Access in and out in southeast Kentucky in particular makes things difficult to recruit companies for economic development purposes.
Thank you. Can you explain, to the extent that you know, what the effect may be if the company did not have the ability to offer EDR contracts and the discounts that are provided therein.
Like I mentioned, it would make us much less competitive in terms of what we could offer a prospect. When companies are looking to locate, of course, there's a whole series of boxes that they need to check, but one of those large boxes is the bottom line, and what is it gonna cost us to operate on that particular site or in that particular area? And power is a big factor in that, in a lot of projects, and especially a lot of projects right now. Power is a huge factor in whether a company chooses to locate. And if it is not cost effective for them to be here, then they are not going to come.
Thank you. Is it your opinion that the company offering these EDR discounts to an entity like Cyber Innovation at the Rock House facility is a way of implementing the General Assembly's plan or construct when they passed the laws that made it, that gave tax incentives and made it easier or more desirable for cryptocurrency companies to locate here?
I think those laws made Kentucky desirable for those kinds of projects, and particularly, like I said, Eastern Kentucky. Not only is power the largest bill in data mining or crypto mining, it's the largest expense of the company, but like I mentioned earlier, we have a number of sites that have been abandoned by coal operations that are feasible and usable by these companies that probably wouldn't be by anybody else.
So by offering the EDR discounts to, for example, Cyber Innovation at their Rock House facility, is the company excluding any other companies like traditional manufacturing that may be able to locate at this site?
No, we would not be excluding another company that may be able to locate at that site. The site is abandoned because it's not of good use for any other kind of manufacturing.
Are you aware if any other customer other than Cyber Innovation were interested in locating at this site?
Several cyber companies looked at that site. Among all of the other ones that we identified, they are the one, Cyber is the one that ended up with purchasing it or the lease, or I don't know exactly what their arrangement was, but they ultimately landed on the site.
Were there traditional manufacturing companies vying for the site?
No.
Ms. Clark, can you please turn back to the company's response to staff 2-2? Are you there?
Yes.
Okay, so earlier you were asked some questions, basically along the line of, absent Cyber Innovation locating on this circuit, would the upgrades identified in this response have been necessary? Do you recall those
I do.
questions? So I think maybe there was a misunderstanding or something, because I think you answered a little inconsistently those questions. But is it your understanding, well, scratch that. Let me point you back to the response. Can you please read the response starting in the second paragraph, in the second sentence that starts furthermore?
Furthermore, these items would be needed absent either Cyber Innovation's Long Fork or Rock House load to address the reliability on that circuit.
Thank you. And understanding you're not the engineer, but this is what the engineers told you, correct?
Yes.
Okay. Okay, I do want to ask some questions about the chairman's questions that were asked during confidential session, but I don't intend to go into any confidential information about when Cyber Innovation started operating. But are you generally aware that prior to entering into an EDR contract, customers regularly enter into a contract for service at full tariff rates until the EDR contract can be approved?
Generally, yes.
Do you know whether Cyber Innovation entered into that type of contract to take service at full tariff rates
I
here.
believe they did, yes.
Are you aware of whether that contract to take service at full tariff rates is in this record?
I'm not aware.
Okay. I believe those are the only questions I had. Thank you.
Is there anything else? Mr. Bowman, Vice Chair? Ms. Clark, you may step down.
Thank you.
Ms. Glass, would you like to call your next witness?
Yes, the company calls Lara Khan.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat. State your name and address for the record.
My name is Lara Khan. I'm a manager for regulatory services for Kentucky Power. My work address is 1645 Winchester Avenue, Ashland, Kentucky.
Ms. Glass?
Thank you. Ms. Khan, did you cause to be filed into the record of this case responses to data requests?
I did.
Do you have any corrections or modifications to those responses?
I do not.
If I were to ask you those same questions today, would your answers be the same?
Yes.
Okay, thank you. The witness is available for cross-examination.
Mr. Horn?
No questions, Mr. Chairman.
All right. I guess let it be known, although he didn't indicate he had any questions, that Mr. Bain has stepped out for a minute. Mr. Snore, any questions?
Yes, Your Honor, thank you.
Please proceed.
Good afternoon, Ms. Khan.
Good afternoon.
Were you involved in the preparation of the marginal cost analysis for this case?
I was.
Was there an errata version or a corrected version of that marginal cost analysis that was filed into the record after the case commenced?
Yes.
I believe that was filed on December 28th. Does that sound right?
I'll take your word for it.
Do you have that with you on the stand?
I do.
You do? Could you turn to that errata attachment 3?
Sure.
Just minor correction, it was filed on January 10th,
Oh, okay.
2023.
Thank you.
I'm there.
Thank you. So I'm looking at what's marked as errata attachment 3, and there's looks like there's two different analyses presented, but both of which have the caption "without generation capacity costs." Do you see that?
I do, and that's a typo. The top one should be without, and the bottom one should be with.
So the bottom of the two analyses should say "with generation capacity costs," right?
Yes.
Could you refer to, do you have with you the spreadsheet that was attached to the response to PSC 1-1?
I do.
Is that a workbook that's associated with this marginal cost analysis?
Yes.
Is it the same, so there's again two analyses, both of which have the caption "without generation capacity costs." Is it the same answer that the bottom one is "with generation capacity costs"?
Yes, sir.
And then, so you have the spreadsheet in front of you.
I do.
There's a tab to the, there's a number of tabs to the spreadsheet.
There is.
I would only like to ask you about what I understand to be public information. So if you think I'm asking you about something confidential, please let me know. There is a tab to the spreadsheet, 5 CP and G cost. Do you see
Okay.
that?
Okay, I'm there.
And this is public, right? This tab.
Yes.
What is shown here in this tab, 5 CP and G cost?
So above the gray line is how we are calculating what the with generation costs would be for the 10 years using the net cone estimate of $220. And then in the bottom, sorry, without seeing it, it's a little hard to tell. I think in the years where we know what the bilateral market purchase costs or replacement for Rockport costs were, those are utilized in the respective years, and then any years where those are not known, then the net cost estimate of 220 is used.
And could you explain, thank you, that's helpful. And could you explain to me as a lawyer and not a technical person, how you would take the net cone estimate of $220 and turn it into the estimates for capacity costs that are shown on this tab?
So I believe it's a calculation that's occurring in these tabs. It's a little hard for me without seeing it there. I'm not sure what the calculation is off the top of my head.
I see. So there's an underlying formula, and you don't recall the specifics of it.
Yeah, I don't recall. The calculation should be shown though in the workbook.
Understood. Thank you. Could you turn back to the summary tab of the spreadsheet?
Okay, I'm there.
So I'm looking at rows 25 to 43 on the summary tab. You see that?
Sorry, I don't have the Excel, I don't have the Excel version, so I only have the rows as they're labeled to go by. Does that make sense to you?
I see. Well, so there's two versions of the,
So, Mr. Smart, if you
Yes.
would like, if it's helpful to you, do you have a go-to-meeting link for this hearing?
I don't.
We can provide you a go-to-meeting link, and you can walk through with the share function, if you'd like, through the big screen, through that non-confidential spreadsheet, if you'd like, with the witness.
That could be helpful. Thank you, Your
All
Honor.
right, let's take a,
Yeah.
we'll take a.
I have it ready. I can pull it up. If
That's right, and that gives him an opportunity to navigate it as he would like, and you've got the confidential version up or the non-confidential version up?
I will switch to the public version so that that does not.
And you may want to exit your Outlook if you have it up, just because we've had a couple instances. So we'll take a short recess. We'll let Mr. Smar have a link to our GoToMeeting link and log in, and then we'll come back in short order. We'll take, well, it's already 3:10. Let's go ahead and take a 10-minute recess, go back at 3:20, and Mr. Smar, you can walk through the document with the witness.
Thank you.
Back on the record, case number 2022-00424. Mr. Smar, would you like to continue your questioning?
Yes, thank you, Your Honor.
Excuse me, sorry, I would just like to note that I was able to provide an electronic copy of this spreadsheet to Ms. Khan on the iPad, so she has that to reference.
Okay.
Thank you. So Ms. Khan, on the screen here is public attachment 1 to the company's response to PSC 1-1, is that right?
Yes.
And I'd like to start, now that we have the electronic version up on the screen, with going back to the tab we were talking about before the break, the 5 CP and G cost.
Yes.
Do you see that on the screen there? So here on this tab, below the tab, starting in rows 14 through 27, I believe you testified earlier those reflect 3 different PJM, the price that the company purchased capacity during 3 different PJM planning years. Is that right?
Yes, my understanding is they're bilateral market purchases. And I did incorrectly state that they were brought up above that gray line. They are not considered above there, so they are informational purposes only.
And I believe those are did you say those were the 3 years that were available to the company at the time this analysis was done?
Yes.
So going back above the gray line, there's a row 5 here. I'm going to highlight it on the screen. Are you able to say what's reflected in row 5?
So it's looking to row 4, which row 4 is what we are expecting their 5 CP contribution to be, and we've got their firm at 1 megawatt, but it's considering it at firm plus reserve, based on what I'm seeing here, to come up with a cost annually.
And so clicking on one of these cells, I'll start with column C, which corresponds with the 23-24 planning year. There's a formula there. Do you see that on the screen?
I do.
It's not up yet. In a moment.
Sorry, I see it on mine.
Are you able to explain what the formula is that resulted in the calculation of that number in column C, row 5?
Yeah, that's what I just described. It's looking to row 4 and what their firm amount plus reserve is to come up with an annual dollar amount for their generation capacity cost using a $220 net cone estimate.
I see. So the...
Mr. Smar, can I ask a couple questions?
Sure.
The dollar, okay. PJM prices capacity on $1 per kW day, right?
Yes, but I think this is putting it times 365 to get to an annual dollar.
Yeah, so, but row 5 is a kW amount, right? It's 1 megawatt plus 15% reserves is 1,150 kW.
I believe so.
And then the subsequent line for that calculation there, we'll just go for C, because C is not a net cone year. The C4 divided by 1,000 turns a kW amount back into megawatt?
Yes.
Right, and then you're multiplying so that's your megawatt, and then your rate is B21 for that year,
Yes.
right? Okay, $34.13 is the BRE clearing price.
Well, sorry, all of these are using the B. Oh, I'm sorry,
you see
I
what
am
I'm-
wrong. We did use the actual bilateral market.
That's why
I'm sorry.
In C and D, you use the amounts from B21 and
Yes, I'm sorry.
B26 or something like that, right?
Yes, I'm
And
sorry.
then by day, so you have dollar megawatt day, right?
And then converted into annual.
And then, okay, and then, yeah, and then you just, since it's in day, then you multiply it by 365, that turns it into the annual capacity cost. So you have the actual amounts from B21 and I think B26 for C and D, and then instead of by the specific cell, E through L is just probably either hard-coded at 220 or referencing B6.
Yes, B6, correct.
Mr. Smart?
Thank you, Your Honor. You fast-forwarded my cross a bit. I appreciate it. So, could you explain then, so how does that 92,345 in column E and then carried through to column L, how is that calculated?
I'm sorry, column E doesn't, it's all just using that 220 after we don't know what the cost is gonna be. It always assumes after that year that it's gonna be at the net cone of $220.
So that's the annual amount based off that
Yes.
net cone. I'm going to go back to the summary tab of Public Attachment 1.
Okay, I'm there.
And so you're essentially assuming that capacity costs will remain flat from year 3 through year 10 of the contract. Is that right?
Yes,
And so it assumes there's no increases in net cone over that time frame. Is that right?
yes, it could be more, it could be less, it's an assumption.
And I believe we had testimony earlier from Mr. West about that the company doesn't actually know what the capacity costs will be beyond the 2 additional years for which they've purchased bilateral contracts for capacity. Is that right?
That's my understanding, yes.
So the assumption here is because you don't know, everything's going to stay the same and there's going to be no increase in capacity costs, right?
It's more that we believe it's the most reasonable assumption or the most reasonable number that we have. So in our most recent base rate case, 2020-174, the commission required us in our cogen SPP tariffs, both of them, to utilize net cone within those. So we applied that same logic here as a reasonable number.
And you think it's reasonable to assume that not just for year 3, but all the way through year 10 with no changes
Yes.
and no escalation over time?
Yes, it could be less.
We could look at, so we're back on the summary tab. There's both the top analysis that's without generation capacity costs and the bottom analysis that's with generation capacity costs have at the bottom a net revenue calculation, correct?
Correct.
And I've highlighted on my screen row 21 of Public Attachment 1, which shows that for the without capacity costs analysis. And so looking across there, am I correct in reading this that if a number is in parentheses, then that means it's a negative number, it's a net cost?
Yes.
And so if there's no parentheses, it's a positive number, it's net revenue, right?
Yes.
And so here on row 21 of this analysis, this spreadsheet, it shows that there's negative numbers in years 2 and 3 of the contract. Is that right?
Yes.
Sorry, Mr. Smart, we still aren't seeing row 21 in the,
I'm sorry, I'm seeing it on mine.
perhaps we could wait until it catches up.
Sure.
Sometimes it does show something slightly different on your screen than on this screen, so you might need to scroll up a tad more.
I'm already scrolled up as far as I can go, just about.
Maybe if will you, Mr. Smart, what my recommendation would be, you hit stop sharing and then try to share again.
Okay.
And just be careful when you share again that you
Share the right thing.
carefully choose the window in which you would like to share. Our first hearing on the record that we ever did, one of our staff attorneys did not turn off was sharing their screen and did not turn off their Outlook notifications. And so the team's comments and email to him about his cross-examination was showing up during his cross-examination. Don't want your peers to be coaching you on the record necessarily.
Your Honor, if it's okay, the witness has a live copy of this.
That'd be fine if you want to go ahead and.
If I could just ask questions based off of that.
That'd be
That's
great.
fine, I just didn't want the record to reflect something we weren't looking at, so.
That's fine.
Would you mind telling us the exhibit and page number you're looking at again now?
It's, thank you, Your Honor. It's response to PSC 1-1, public attachment 1.
And you're on the summary tab, is where
And
you're
we're on
asking
the
questions right
summary
now.
tab, yes.
Row 21, I believe.
And we were just asking about row 21, which is the net revenue calculation for without capacity costs being included. And I was actually just going to move on to looking at the net revenue calculation in row 43, which is the analysis with capacity costs included, correct?
Yes.
And there, it shows that in years 2, 3, and 4 of the contract, there's a net cost, correct?
Yes.
And so what this shows is that even without capacity costs, negative revenues in years 2 and 3, with capacity costs, negative revenues in 2, 3, and 4, that means that the later years of the contract are being relied on from a revenue standpoint to make up for losses during the early years of the contract. Is that right?
Yes, which is to be expected on a contract that heavily discounts in years 1 through 5. So year 1 being typically if they follow the 50, 40, 30, 10, 20, 10, you would expect that, or I would expect that.
And so if the Rock House facility ceases to operate prior to those later years, this contract, even assuming all the numbers in here are correct and capture all the revenue and costs, would be a net negative for ratepayers. Is that right?
No. So first, I can assure you that these costs won't be exactly what actually happens because it's based on a set of assumptions. But that being said, tariff EDR has callback provisions that should the customer exit the contract before the full contract term, they're required to pay back every cent of the discounts that were given to them.
What if they don't have the resources to do that?
So in this case, we'll have a surety bond.
I believe there was some discussion earlier, there's no written surety bond currently, correct? So that would assume that there is a written bond that's executed in connection with the
Yes, and I
contract?
think we've committed to seeking that written confirmation.
And how are you going to, given the statement that this is all based on assumptions in terms of the the potential costs and revenues, how will the bond be calculated to ensure that it fully covers and protects ratepayers in the event that the facility ceases to operate?
So from my perspective, in utility rate making, we're never going to get everything precise, but the attempt here would be at the beginning of each discount year to determine what their, their discounts under tariff EDR are going to be and require that amount to be provided beforehand.
So the bond will operate on a year-to-year basis?
That's my understanding of how the customer would like this to fall out. So in the first year, we would require the bond that they would have for we would require a bond that would be sufficient to cover year one, and it would be cumulative with each year getting a new portion added to said bond.
And again, none of this is in writing or in the record of this case, correct?
Yes, but we've committed to seeking that.
Could you look at column M on public attachment 1?
Yes, I'm there.
Am I correct that it's not labeled, but am I correct in reading that that's a total of the preceding 10 years columns, the columns representing the 10 years of the contract?
Yes, it's taking the sum of all the other columns for year 1s through 10.
And so if we go back to the rows we were looking at before, row 21 is the net revenue or cost without capacity costs included, and the value in column M is 1,155,930, correct?
Correct.
And that represents, in this analysis, the total revenue net revenue that would be earned over the 10 years of the contract without the capacity costs included, correct?
Correct.
And then if you go down to row 43, column M, the number is 380,177, correct?
Yes, correct.
And that represents the net revenue with incremental capacity costs included as is estimated in this analysis, correct?
Correct.
Could you look up at row 39?
Sure, I'm there.
This would be in the with capacity costs scenario, a calculation of incremental transmission costs, correct?
Correct. I believe in this case it's being escalated at 5%.
And so there was some discussion of this during the hearing we had last week on the E-bond contract, right? About whether that assumption of a 5% annual increase is reasonable, correct?
Correct.
Is it fair to say that Kentucky Power handled this transmission escalation of transmission costs issue here in this analysis in the same way that it did for the analysis in the E-bond contract?
Yes.
And so the questions that were raised in the E-bond hearing about the reasonableness of projecting a 5% annual increase for transmission costs would apply equally here, correct?
Yes.
So we were just discussing that in row 43, column M, the positive net revenue margin is only 380,177, is that right?
Correct.
And so if Kentucky Power were to have assumed a higher transmission cost increase per year than 5%, that could have the effect of tipping this analysis from positive to negative. Isn't that right?
I would maintain the same comment I made in EBON, which is you would also need to increase the revenue side of the equation for PPA. So I don't know that it would, but it could.
And especially if it's more, like if it's, maybe it's less of a difference if it's a 6% as opposed to 5%, but if it ends up being more like a 10% assumption, that would be a much greater increase per year, correct?
Correct.
Did Kentucky Power undertake any effort to stress test this marginal cost analysis using different escalation rates for transmission costs, given the extremely slim margins here?
No.
One moment, Your Honor. Going back to the, one last question, going back to the question about the bond, is it your understanding that Cyber Innovations Group has found an entity that is willing to bond them year to year throughout the entire 10 years of this contract?
That would be my understanding, but I have not been involved in any of those conversations.
I have no further questions, Your Honor. Thank you, Ms. Conch.
Did you have anything?
No questions, Your Honor.
Mr. Bellamy?
Yes. I'm actually just gonna pull this up really quick. I was just looking at, sort of the same thing that you were just discussing, the margins on the, apologize. So this is the, I'm looking, I guess, here at row 21, column M. And you know what, perhaps this thing just doesn't work on here. I think I'll just stop sharing myself. I'm thinking Excel just doesn't work very well on this thing.
It just moved, if you want to.
Okay. So, this 1.15 million, that's the, I guess, the extent to which in the marginal cost analysis that you calculated Cyber Innovations would be covering more than their marginal costs without the capacity costs included. Is that correct?
Correct.
And I just wanted to note the 1.15 million as compared to the incremental revenue there, it's approximately 3%. Would you agree with that?
Sure, subject to check, yeah.
Sure. And then down here, which I'm going to row 43, if it pops up.
I'm there.
This 380,000, that's the, I guess, the extent to which the contract is in the positive if you include the marginal, or the capacity cost, is that correct?
Correct.
And then as compared to the, again, the 37 million in revenue, that's about 1% or so.
Subject to check, oh,
Sure.
yeah.
I'm just gonna pass out, this is the marginal cost analysis for the other Cyber Innovations tariff. That approach? Yes.
you like to mark this?
Yeah, I'll move mark it as staff exhibit 1.
Okay. Thank you. We'll get you one. You can email a copy of it.
I'm just looking at attachment 3, which I believe is kind of a summary of the marginal cost analysis. And this is, the document labeled attachment 3, it doesn't have any capacity costs in there, correct?
Correct.
So, I guess the net revenue on this marginal cost analysis, it's 918,000, with incremental revenue of about 8 million, which puts the, again, subject to check, but I guess the percentage of net revenue at about, 11% over the total revenue. What made, these are the same, it's the same company, and we've been told that the two facilities are close together. What made this one so much more positive? Do you know?
I'm sorry, I'm not aware.
Okay.
I probably did not prepare this one, simply because it's not in Times New Roman, is my indicator.
That's the font you like?
Yeah. I'm very specific about how things look, yeah.
Okay. No, I appreciate that. With the, I guess the margins being so slim, is there any particular, point of concern that you have that, is likely to tip it into the negative on the current contract that we're talking about here?
So I guess not particularly, mostly because the protections that we have. But I guess I would have possible concerns about transmission costs escalating beyond, and I'd want to look at what that does relative to also considering PPA revenues increasing. But that would be my really only sole concern. As far as generation incremental costs go, I'm not concerned because my understanding, based on Mr. West's testimony, is that this 1 megawatt firm is really just a rounding error, so it's not likely to actually cause us to incur costs related to it.
Okay. With respect to, I did have some questions. It sounds like you would need to look into it more maybe, but because I think there were some questions about in the written request for information regarding the escalation of the transmission costs, and I believe, at least some of the response might have been that, those would be recovered through the PPA.
Correct.
Would it be on a one-to-one basis that the incremental transmission costs arising from Cyber Innovations service would flow through on a one-to-one basis effectively through to Cyber Innovations through the PPA?
No, there's no way we can guarantee that, and I'm pretty sure we've stated as much in our discovery. I can try to find that if you'd
Okay.
like.
No, that's fine. How, could you just kind of give a brief explanation of how it would flow through the PPA?
So, I like to see it. I think it would be better for post-hearing to
Okay.
probably try to walk through that.
Okay. I did have a couple questions just really quick, and I don't know, this might even help you answer this question. Regarding the revenue page, Chairman, if we could maybe go into a confidential session, that's the portion that shows Cyber Innovations
That'd be fine.
usage information that I think is confidential.
Yes.
Mr. Bellamy?
How did you determine to use when you were calculating, I'm on this tab 5 CP and G costs, how'd you determine to use the 1,000 megawatts plus a 15% reserve margin? I'm sorry, the 1,000 kilowatts and the 15% reserve margin?
That was just provided to me by our Columbus experts.
Okay. Was there any discussion of increasing the demand to reflect the possibility that the company might not interrupt service at each 5 CP each year?
Not that I'm aware of.
Would you agree that if the company didn't interrupt service at each 5 CP, that would increase the demand costs in the subsequent years?
Not necessarily, because at this load, it's possible that we would have to contract for, I'll call it a tranche, so a block of replacement capacity at X amount, and it's possible that regardless of that increase, it's still covered at that, what they didn't interrupt.
If the marginal analysis turns out to be incorrect and Cyber Innovations ends up not covering its marginal cost of service, what would happen to that additional costs that was not covered by their rate?
My understanding, it would be recovered during a rate case, but I would need to talk to our Columbus folks who do the rate analysis.
Was it your understanding that it would most likely be recovered from other customers?
Yes.
Was there any discussion of any other mechanism to recover it, or the company through its shareholders covering part of the costs?
Not that I'm aware of.
I don't have any other questions.
I have some questions. I'm trying to think of the best way to ask them. So let's do this first. Try to do this quickly, efficiently. Just 1 second. This tariff PPA.
Correct.
Okay. This is the calculation for the annual purchase power net cost, is that right?
Right.
Purchase power net cost is the N plus CSIRP plus the OAT plus the RKP plus RP minus BPP, is that right?
Right.
Okay. So, N is the annual cost of power purchased by the company through new purchase power. Do you know whether these incremental power purchases that the company has been doing are included in this N?
It's my understanding that they are.
Okay. So when it says, all new purchase power agreements shall be approved by the commission to the extent required by KRS 278-300. Okay. Then CSIRP, the net annual cost of any credits provided to customers under tariff CSIRP, tariff DRS, tariff VCS, and special contracts for interruptible service above or below $454,997 included in BPP, right?
Right.
Okay. So incremental DRS credits are actually flowing through to all customers through tariff BPA. Is that right?
Right.
Okay. Then OAT. OAT tracks 100% of the incremental or decremental transmission expenses, correct?
Correct.
Okay. Do you know what PJM LSE OAT expenses were for calendar year? I know the answer is going to be no. But for calendar year ending June 30, 2022?
No, I don't remember.
Okay. Let me see here. It's coming up now. This is an Excel spreadsheet filed in, November 15th, 2022. It's the tariff PPA update that's filed in the post case correspondence in case number 2021-74. Do you make this filing every year?
So the first year I did it was probably last year, and then
Okay.
I also did this update. That was a November one. That was, I'll say it's abnormal because we normally just file once a year.
Yeah, but you're familiar with this document, right?
Yes.
Okay, so on this is the summary on the first page, and then this is the change post. How do I say this? So you all filed this earlier in the year, and then you had to file a subsequent one because tariff PPA the Rockport cost needed to be removed from tariff PPA. Is that right? That's the $10 million amount.
Right. There's also, so I think there's 4 things going on there,
Okay.
shown in column H.
But that's why there was a second one that filed that year, is because of the expiration of the Rockport UPA, right?
Right.
Okay. So form .0 has the PJM LSC OAT expenses, right?
Right. And I believe that's carried forward from 3.0A, which is prepared by our accounting team.
Okay. So we've got an incremental $13.8 million in excess of the base amount. Is that right?
Right.
Okay. And the base amount was $96 million, $96.8 million, and that's what's on tariff PPA, right?
Correct.
Okay. So now it is $110 million. I mean, that's
Oh.
what it says on line 22.
Oh, sorry. I thought,
It's okay. I'm not making it's all right.
yeah.
All right.
Yeah.
So it's $110 million. I'm going to show you a different document here. This is a post-hearing data request response by Kentucky Power in case number 2017-179, which is the 2017 Kentucky Power rate case. And you see at the top that this is Kentucky Power Company AG post-hearing data request number 3, test year PJM LSE OAT expense associated with affiliates and non-affiliates.
Correct.
Do you see in column O, it's getting there, I promise. Column O, line 18.
Yes, but I've lost what the identifiers on the left were.
That's okay. But the amount is $70,212,659.
Correct.
You see the column is entitled Test Year Total,
Yep.
and I'll go all the way back. And that's just the total PJM LSE OAT expense.
Yes.
So it was 70 million on this from the 2017 case. The 2020 case, it was 96.8 million, right?
Correct.
And as of June 30th, 2022, it was 110 million.
Correct.
Okay. Have you seen any updates since then?
No.
Okay. Would you agree that PJM LLC owed expenses seem to be? See if it stops sharing. Okay. That PJM LLC owed expenses seem to be increasing at least since 2017 at a pace faster than 5% per year?
Yes.
And you stated earlier, IGS, in addition to LGS, are one of the two classes, well, IGS and then IGS time of day, and LGS, and I think maybe LGS CSIRP, they're the ones that get allocated, purchase the tariff PPA on a KW basis, right?
So I think I just said IGS,
Okay.
but I'll take your word on the other one. I can't recall.
It's okay, I have the tariff in front of
Okay.
me. There's two columns, one that has a KWH, one that has a KW.
Yeah.
They just are what they are, but IGS and LGS are the two primary rate classes that get a demand allocator, right?
Yes, on top of, so they get a KW rate on top of a KWH. They have to pay both.
That's, yeah, thank you. You had never seen that marginal cost analysis that you were provided earlier from the other cyber innovative case?
I've probably seen it. I think my response was that I didn't prepare it.
Okay. There's a different discount rate in both of those. One is 10.15%, the other is 10.55%.
I'm sorry, what do you mean by discount rate?
I think that's what it's referred to as. Carrying cost. I don't know what other term it uses. Levelized carrying cost?
Oh, okay, for the distribution?
Yeah,
Yeah.
yeah. Where'd you get the 10.15 from?
Oh, that comes from our Columbus forecasting, budgeting and forecasting team. They look at I believe it's the 30-year, what a 30-year investment is going to cost, but it was provided to me.
Is that like a Handy Whitman index or some other factor?
I would have to reach out to them and ask.
That marginal cost analysis assumed 3-cent power. Was that
Sorry,
surprising?
the Long Fork location?
Yes.
Okay.
Does that surprise you?
Yes.
Okay. Your marginal cost analysis assumes close to 4.5, 5-cent power, right? Based off of forward-looking day-ahead prices.
So I didn't actually use forward-looking LMP prices. I set that row for energy to our fuel 12-month average fuel plus base fuel.
Okay. Effectively, the marginal cost of energy is, how do I say this? The way you do your marginal analysis is negated entirely in each year's nominal value, because whatever the marginal cost of energy is also equal to the marginal revenue from energy. Is that correct?
Yes, they equal each
Okay.
other.
Let me ask it this way. The hearing we had last week, is there going to be a difference on the impact of average fuel costs between the addition of a 1 megawatt facility versus a 250 megawatt facility?
I'm not sure, sorry.
Do you recommend using the levelized carrying costs, whether it's 10.55 or 10.15 or some other number, some other discount rate, in calculating this instead of using nominal benefits or nominal annual amounts, using a present value analysis to determine whether it's a positive or negative benefit to other customers?
No, I don't have a deference for one or the other. I think our approach was reasonable.
Do you think that it should be a net present value analysis?
Sorry, I'll just restate what I did. I don't have any deference for one or the other.
Okay. You would agree that a benefit of $150,000 in year 10 is not the same as $150,000 of benefits in year 1, would you?
Yes.
Oh, I do. Do you have that confidential, whatever it is, but the PSC 11 private, public or confidential?
I
It
have
was
the
stated earlier, I
confidential.
just want to get it on the record, fixed on the record. Let me know
Yes,
when
I have
you're,
a copy.
you're on tab summary.
Yes.
Okay. On line 25, and line 3 both say without capacity costs. Would you agree that line 25 should say with generation capacity costs?
So unfortunately, 1 second, sorry, I
That's
need to
okay.
go to the Excel
And you can
version
go to
of it.
that. It's actually the same in your errata 3 that you filed in January. It does the same thing on the.
Yeah, I think, sorry, when I say that, it's because I'm not seeing the Excel rows
That's okay.
and I can't
I
see
need
them.
to lock the iPad.
That's fine. That's fine.
But subject to check, yes, I agree with that.
I just want to make sure that we've got the right evidence here.
So row 3 should say, or does say without generation capacity costs, which is correct, and then row 25 should say with generation capacity costs.
Okay. All right. So the bottom calculation is with generation capacity costs.
Correct.
Okay. And the same for your cumulative one that you filed a new version of in January, the errata one. The top should have been without and the bottom should have been with, right?
Right.
Okay. So, if I asked you directly, what was your PJM LSE oat transmission expenses in 2019, right? Calendar year 2019. Is that a question that you would ask somebody at AEPSC and they would give you that amount? Or do you think you have that at Kentucky Power?
No, I would have to go to AEPSC and ask for it.
Okay, great.
They
So-
have a over-under calculation that they're constantly, that Form 3.0A is what they're tracking, and that's who I would go to get that information.
Okay, so as opposed to your data request, we'll just ask for the annual amount, going back a number of years. I'll leave it up to Mr. Bellamy how many years back as a posting your data request so that we get a good appreciation of what that escalation actually is.
Sorry, can I correct myself? Just, in that case, if it's historical, I could easily just go pull our old PPA filings to
Okay.
get it. So-
Yeah, even if it predates PPA?
No, then I would
Okay.
probably need to do it.
And then, let me just ask, if your answer earlier is very, I think, fairly reasonable to Mr. Bellamy's question about what if the transmission, goes up more than 5%, there would be an offsetting amount of incremental revenue.
Right.
So if the amount went up, whatever factor, let's say, I'll make it up, but we can ask the post in your data request. If the factor that transmission expenses since 2016 have gone up, between 2016 and today, the annual factor is 9%. If I told you that, and it affected line 9, PJM LSE transmission, and assuming everything else constant, would you be able to rerun this scenario and figure out what the incremental revenue of that would be?
Sorry, are you asking me if I assumed that 9% on both the transmission line and then also a 9% in PPA revenues?
No, I'm trying to make sure I have an appreciation for whether we can actually check your answer earlier. So Mr. Bellamy asked you that if the PJM LSE transmission expenses actually went up, that would erode the economics of the analysis. And you said, Yes, and I'm paraphrasing here, and then, but he specifically said, would it make it go negative? Would it make it go, and your answer was, I don't think so, because there would be an offsetting increase in the revenues. And what I'm asking is, if we assume the only change in variable is a larger increase in PJM LSE transmission expenses from something at 5% to something higher, would you be able to, based off that single change in variable, correspondingly increase the incremental revenue pursuant to the response that you gave?
Yes, I believe so.
Okay. So we may ask as a posterior data request as well. Do you know what ROE that the company received in the 2020 rate case? Or what its rates
For
were
base
based on?
rates, it was 9.3. For the environmental surcharge and decommissioning rider, it was 9.10. So yes.
Have you seen it, in economic analyses, have you seen people use an approved ROE or proposed ROE as the discount rate to determine a net present value amount?
I have not, no.
Okay. All right, Ms. Glass, do you have any redirect to this witness?
Yes, just a couple.
Please proceed.
Okay, Ms. Khan, would you generally agree that there is more than one reasonable way to perform a marginal cost study?
Yes.
Would you agree that the marginal cost study has to be based on info known at the time that the marginal cost study is developed?
Information known and assumptions made based on, well, in our case, what we believe to be reasonable.
Thank you. Would you agree that a marginal cost study cannot and should not be used to predict the future?
Yes.
Would you agree that the company used reasonable inputs when it was preparing its marginal cost study in this case?
Yes.
Would you also agree that a marginal cost study doesn't represent every single real-world event that would or could happen over the course of the contract?
Yes.
For example, the end of the tariff FTC credit is not reflected in the revenues row of the marginal cost study. Is that your understanding?
Yes.
Can you explain to the best of your ability what effect the end of the tariff FTC credit would have on that revenues row?
Trying not to go into confidential. If I go to the revenues tab, I don't know if I can do this
Could we go
without
into
being
confidential session so she can answer?
Please just let me know when we're in confidential session, please. Claus?
I don't have any further questions, thank you.
Anything else, Ms. Cohen? Thank you very much.
Thank you.
Ms. Claus, would you like to recall any of your witnesses?
No.
Is there anything else from the applicant in this case?
No, there is not. I just note that we have 2 motions for confidential treatment pending that I'm sure the commission will review, but that's it.
We'll look again, but
I'll check on that. I thought we did.
I thought we, that's okay. Yeah.
I may be mistaken.
No, that's okay.
I apologize if I am.
We've gone through a lot, so. And then, before we turn it over, and allow the joint interveners to tender their witness or provide their witness, I want to go back to the timing question earlier. You said you wanted an opportunity to address. Are you wanting an opportunity to address factual or evidentiary issues with regards to the sufficiency of generation or legal arguments with regard to sufficiency of generation?
I would say both. Factually, to the extent we need to supplement the record with any information that our witnesses here were not able to provide, or any context that may be helpful in understanding the information that our witnesses did provide. So that would be, evidentially through the record, through post-hearing data request or supplemental testimony, but also perhaps legal arguments with the opportunity to brief.
And that's fine. I mean, I think I don't have any post-hearing data requests. The other commissioners may, commission staff may. And, I don't know, given that we're having the hearing today, that there's and especially, I think the statutory date in this case is September 16th. So I don't, there's not an opportunity for another hearing, I don't think necessarily. So I guess I'd put it to you, unless you think you can have another hearing in a week and bring in the people that you anticipate, happy to give you an opportunity to conduct some direct examination on this issue, but I don't know that we necessarily have time to supplement the record with additional evidence if we can't have another hearing.
Could we request a post-hearing data request from commission staff that would give us the opportunity to provide
Yeah,
extra
I guess I
evidence?
still don't understand what evidence you would like to provide in regards to that.
So I think particularly what I'm thinking about now is the issue with the tariff EDR provision that allows for reduction of the credits. We have to make capacity purchases. We were only able to have a brief conversation with what I'll call the subject matter expert in that regard, and Mr. West is only able to provide, information to the extent that he knows how that works or what he was able to glean from that short conversation. And so I believe that there is additional evidence that other subject matter experts would have and could provide that would either provide necessary additional evidence or necessary context for the evidence that was already given.
And that's helpful, except I don't know that I have a problem with the way that the dollar for dollar would be purchased. I mean, it is a tariff provision. If it has to be implemented, it has to be implemented, right? I mean, it's been a tariff provision since no, that's correct, incorrect. I think maybe since 2018, it's been a tariff provision. So insofar as how you all are going to do it, I mean, we can certainly ask a data request to that extent, but my understanding was your request was specific to the final order and the IRP and the sufficiency of generation and the way that you all have carried out your FRR plan, or Mr. West's perspective of what the of what your all's capacity position is relative to being sufficient or excess, or I don't know what else, but I'd also say I don't know that it would have been a surprise to the company that the sufficiency of generating capacity was not a surprise that it was going to be an issue in this hearing, and you all could have submitted testimony, brought whoever you would like to provide evidence on that matter, and we're kind of put in a position where it's July the 25th, and we have to rule on the tariff or the contract that's in front of us by September the 16th, and part of the testimony today is that tariff or contract may be subsequently amended. So we're kind of put in a position where it's not like a suspension date where you all can agree to forego placing rates into effect subject to refund. The 278, 190 is a hard stop when we hit September 16th. So I'm fine to let you support the evidence however you'd like, but I thought that was in large part the purpose of the hearing today. And I think second, I hear your interest in providing a legal brief, and I am interested, I think the commission, all three of us are interested in providing or receiving legal briefs in this case. And we've got to give some consideration to having enough time for you all to complete those and for us to read them before we render a decision in the case.
Understood. May I respond?
Yeah.
So my specific request for additional opportunity to provide evidence was with respect to the capacity purchases and credit reduction issue.
Okay.
However, I think maybe it was Mr. West on the stand that referenced the show cause proceeding and our response provided in that matter. And I also believe, or I was under the understanding that the commission staff would be perhaps issuing a post-hearing data request in this case similar to that which was issued in the E-bond case concerning those issues, the sufficiency of the company's generating capacity and strategy. So I was treating those as two separate issues.
That'd be fine. So, you mean specific to my question, I just want to make sure it's clear. You would like a post-hearing opportunity to file and respond, for the company to respond, I'm sure you don't want to, the company to respond to a post-hearing data request regarding the actual mechanism by which you all will would implement that dollar-for-dollar reduction for the capacity charge, is that right?
Correct. When it would be necessary and how it would be implemented.
That'd be fine.
Okay, thank you very much. I appreciate that opportunity.
And then we'll talk about it, post-hearing briefing after the presentation of evidence. So, Mr. Gary, Mr. Smart, would you like, I'm sorry, Ms. Glass, is there anything else from the applicant other than the possibly 2 petitions for confidentiality?
No.
Mr. Smart, Mr. Gary, would you like to call your witness?
Yes, Your Honor, thank you. Joint interveners would call Stacy Sherwood.
Ms. Sherwood, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes, I do.
Please have a seat and state your name and address for the record.
My name is Stacy Sherwood, and my business address is 10298 Route 116 in Heinsberg, Vermont, 05461.
Mr. Smart?
Thank you, Your Honor. Good afternoon, Ms. Sherwood.
Good afternoon.
Did you cause testimony to be filed into the record of this case?
Yes, I did.
And did you also cause answers to data requests to be filed into the record of this case?
Yes, I did.
If I were to ask you the same questions today, would your testimony and responses to data requests be substantially the same?
Yes, I would.
Do you have any corrections that you would like to make to either your testimony or your responses to data requests?
No, I do not.
Thank you. Your Honor, the witness is available for cross-examination.
Mr. Ward?
No questions, Your Honor.
No questions, Your Honor.
Ms. Glass, do you have questions?
No
Ms. Sherwood?
questions.
We do not have any questions.
Okay. I'll ask you a question I asked Ms. Khan earlier. Have you seen utilities or analyses regarding utilities use the approved or proposed return on equity as the discount rate, or sorry, not return on equity, weighted average cost of capital used to set rates, used as the discount rate when doing net present value analyses?
Yes, I have.
Okay. And in what instances just curious what your experience of that is, like CPCNs, smart meter overhauls, replacement rates? I'm curious, specific, are there times where that makes sense and times where it doesn't, to do a net present value analysis, or a net present value analysis looking at a backwards looking weighted average cost of capital?
So where I have seen it is in smart meter cases. Yes.
Okay, where somebody's, are those cases where somebody's proposing to get rid of meters that work and replace them with other meters, and they're trying to show that the benefits of the new meters?
Correct. Yes, in the cost benefit analysis, yes.
Okay. Is there an alternative or a better discount rate than the weighted average cost of capital in your experience?
Not that I've seen in those cases, no.
Is the company's time value of money the same as customers' time value of money?
No.
Okay. With those smart meter cases, it was really about the company's investment in new metering infrastructure, right?
It was about that, but also that the benefits exceeded the cost so that ratepayers would actually incur a benefit from the implementation of smart meters.
Right, and I guess what I'm saying is the investment by the utility, really, it's a capital investment to offset or reduce operating expenses. Is that the big picture of the economic analyses you're familiar of?
Yes.
Meter readers, whatever the truck rolls, whatever recurring O&M incurred, is that right?
That's correct. I mean, you could expand upon that to include a website update so that they can actually track their usage and monitor what they're using, and other green button technologies.
Okay. So weighted average cost of capital could be a proxy for time value of money, but at least in that regard, it was being applied where capital was being employed. Right?
Correct.
Okay. Have you done any economic analyses to look at the if a customer's, or I say a customer, a utility customer, commercial, residential, maybe the average utility customer, whatever we want to refer to it as, is there something you've used or seen used in economic analyses as a proxy for time value of money other than a utility's weighted average cost of capital?
Not in my experience, no.
Does the opportunity to the utilities, I guess, oral representation today and possibly updated addendum or whatever to the contract regarding surety on the quote, we called them last week, clawback provisions, or the repayment of discounts that are provided insofar as they don't follow through with the entire term of the contract. Would a contract provision requiring surety of that amount each year incrementally as the discounts are provided reduce some of your concern around the risk to the rest of the system should this customer not operate through the entire term of the agreement?
Yes, it does alleviate some of those concerns, but it doesn't alleviate the fact that there's potential to not be a benefit to customers in the end, that it could end up costing them to provide the discount.
Okay, and that's different, you're saying that's different than having to pay back the discount. You're saying if the reality is different than the marginal cost study, it could be detrimental to customers, is that?
Correct.
I'm not
yes.
trying to testify for you, I just wanna make sure, okay.
Yes,
You're
that's
saying
correct.
they're distinct.
They're distinct separate issues, but I think the surety bond does help in a way. So where I've
Yeah.
seen surety bonds come in previously is like with third-party suppliers, particularly in Maryland is my experience. And so they have a surety bond up front when they've entered the market, when third-party suppliers enter the market. And then during certain storms, some of those suppliers went away and those surety bonds were called back in order to help customers. And so I've seen that be a way to recoup some of the lost costs that would have been stranded on customers.
Okay.
My one concern there is the year-over-year surety bond, and whether or not each year there's going to be a company that's available to actually provide that surety bond.
Lapsing. you mean?
Correct.
Yeah, okay.
Did you have a question?
I just wanted to, I forgot to ask you, I had this in my notes, but can you just talk through the town of Plattsburgh, is that how you say it, in New York, and what happened there?
Yes, so in that case, they had a power procurement that they have established of the maximum amount that they, of power that they could have each year, correct? And they, with the addition of the cryptocurrency customer, they went over that amount, and as a result, had to purchase additional power, which increased the overall cost to all the customers in the Plattsburgh area.
Okay, and the increased tax revenue and the jobs didn't really
That
offset?
did not offset the cost
rate, the
increase in
cost.
power, yes.
Okay, all right, thank you.
Mr. Smaller, any redirect?
No, Your Honor, thank you.
Is there any additional questions for this witness?
No.
Ms. Wise? Mr. Warren? Mr. Bellamy? Vice Chair? Thank you very much, Ms. Sherwood.
Thank you.
Is there anything else, Mr. Smarr or Mr. Gary from the joint interveners?
Nothing from joint interveners.
Okay. Mr. Horn, Graham, you all don't have any witnesses in this case. Is there anything that you all need to bring to our attention today? So we'll move on, as I promised, to discuss some post-hearing timing. I do think it's clear we'll have some post-hearing data requests. When do we think we can ask those by?
I would say Friday.
Okay. So we can issue a post-hearing procedural schedule and post-hearing data requests by, is that the 28th?
Yes.
It's like they put this up here for a reason. It's great. July 28th? Ms. Glass, how long would you need to respond?
7 days would be great.
That'd be great. August the 4th?
Yes.
Okay. Given the timing, we would do, and I assume the interest in providing post-hearing briefs. Does anybody have objection to doing simultaneous briefs and simultaneous response briefs?
No.
No objection.
All right, so I would like the case to be submitted, given the statutory date in this case. I'd like to have the case submitted by, I'd really love September the 1st, but I'll take September the 5th. Well, let me ask a very honest question. Are any of you actually going to be working the weekend of September the 2nd through the 4th?
Depends on the outcome of this discussion.
I have a wedding to go to, so I'm hoping not to be.
So let's just go ahead and make it September 1st to be submitted. So the response brief would be September 1st. When would you all like the initial brief to be working back from that? August 28th?
That'd be fine with the company.
That'd give almost everybody 24 days after the close of evidence, or effectively 24 days after the close of evidence to file the initial brief. Is there any objections to that?
Just to clarify, Your Honor, so August 28th would be the initial brief,
Yep,
and then September 1st would be the reply? Yeah, I have no objection to that.
that's right. All right, so August 28 and September 1st. Case will be submitted 12:01 on the 5th. No, I'm sorry. 12:01 on the 2nd. Okay. Is there anything else? Everybody fine with that? We'll put it in the post-hearing procedural schedule, but I'll reiterate it today just so everybody is on notice that, don't put anything in a response brief that is not initially raised in another party's, initial brief. Okay? All right, thank you all very much. This hearing is adjourned.